All right. Everybody stand up for this, please.
I don't think he needs to come in, Saunders. Garcia. You can be seated. Thank you, everyone. Okay, good morning, everybody. My name is Commissioner Hughes. This is the 8 a.m. initial appearance calendar for Thursday, March 27th. The court's orders for the taking of DNA samples and fingerprints issued on the first calendar of the month will apply to the hearings on this calendar. Okay, my apologies. All right, everyone, as we get started in here this morning, I will call each of you into the courtroom one at a time. I will ask one of you to stand behind this gray podium here in front of me in the courtroom. I'll ask the next two people that I intend to call into the courtroom to line up in the two chairs right inside this door. So that's how we'll cycle through this calendar. You'll go from where you are now to the second chair, from that chair to the first chair, from the first chair into the courtroom. I know that seems sort of like a little bit of musical chairs, but I promise you all it will make this calendar move quicker. So if you will please listen for your name and follow the chair progression, it'll get everybody to where they need to be after this a little bit quicker. Once you work your way into the courtroom and you're behind the podium, I will start by asking you to state your full name and date of birth. After that, I will explain to you why you're here this morning. I will then tell you whether you qualify for a court-appointed lawyer, sometimes called a public defender, to represent you. Whether or not you qualify for a public defender, you have the right to hire a private lawyer at your own expense if you wish to. After we talk about lawyers, I will give you the next court hearing dates and times you'll be required to attend after this court hearing. And the last thing we'll do while you're in the courtroom is talk about whether you are legally eligible for release from custody. If you are, we will go over on what terms and conditions you can be released. In addition to that right to the assistance of counsel, you all also have the right to remain silent. Anything that you choose to say in the courtroom this morning will be preserved on the recording and can be used against you at any point down the line in these proceedings. Whether or not you qualify for a court-appointed lawyer, unless you have made arrangements with a private lawyer to represent you in here this morning, there will not be a lawyer for your defense. For those of you that will not have a lawyer in here, because you won't have a lawyer and because anything you say could be used against you, I will strongly caution you not to make any statements on the recording regarding the facts about why you're here. I encourage all of you to save any questions, comments, statements you might have about the facts of your case for a hearing where you have counsel present to discuss that with before you make any statements you can't take back. Last thing I'll tell you before we get started is that all of the information I give you while you're in the courtroom will be contained in a written document called a release order. You will get a copy of that document when you're done in the courtroom and you step back into the room that you're in right now. So please don't feel like you need to memorize the information we go through here in the courtroom, but do please keep that paperwork with you wherever you go from here, because in that paperwork will be all the information you got in the courtroom. All right, let's go ahead and get started if we could. Can I please have Quinn O'Neill all the way into the courtroom behind the podium? Jorge Giacomi, if you would work your way to the first chair inside the door. Paul Cardenas, if you would work your way to that second chair, please. Good morning. May I please have your name and date of birth?
Quinn Everett O'Neill, 10/7/76.
Thank you very much, Mr. O'Neill. You are here on 3 different matters. The first matter we'll cover is a felony warrant issued by the Pima Consolidated Justice Court. It looks like the underlying allegation in that case is a felony burglary allegation. If you have not already been appointed a lawyer in that case, but you think you're entitled to one, that ruling needs to be made by the Pima County Court and can be done at your next hearing if you bring it up with the judge then. That next hearing in your Pima case will be an arraignment hearing April 1st. It'll take place at 8:30 in the morning in the Pima Consolidated Justice Court. On that warrant, you have a $10,000 secured appearance bond. The second matter that you're here on is allegations of new felony offenses committed, it looks like January 20th of 2025. That allegation is one count of trafficking in stolen property. It is a Class 3 felony. I have found probable cause to support that allegation, and I did appoint a lawyer to defend you in that case. Your next court hearings in that new trafficking case will be a status conference April 2nd and then a preliminary hearing April 4th. Both of those hearings will also be at 8:30, but those in the Maricopa County Superior Court here downtown. On that new trafficking allegation, you have a $25,000 secured appearance bond. The last matter that you're here on is an allegation that the new trafficking charge violated Term 1 of your probation. In the probation case, I've also appointed a lawyer to defend you. Your next court hearing in that probation matter will be a revocation arraignment hearing April 3rd, also at 8:30, also here in Maricopa County downtown. On the probation matter, you are not eligible for release on bond. That means you will be held in custody without bail at least until you see the probation judge on April 3rd. Because of that, I encourage you to wait until after that probation hearing before attempting to post your bond on the new trafficking charge or the Pima County warrant. If you posted those bonds anytime between now and before that hearing on the 3rd, you still wouldn't be released. You would be held to be taken to the probation court for that probation hearing. So I would encourage you to just hang tight until April 3rd when you see the probation judge. Depending on what happens at that hearing, you could then look to post your bond in the other two cases if you still have one, and then you'd be eligible for release. Okay, do you understand all that information, Mr. O'Neill?
Yes, I do.
All right, thank you very much. You can step back and get your paperwork. Jorge Giacommi, if you would please work your way into the courtroom. Apollonio Alvarez, if you would please work your way to that second chair. Can I have your name and date of birth, please, sir?
Jorge Giacommi, 90102.
Thank you very much, Mr. Giacommi. You are here on two different matters. The first matter that you're here on is allegations of new charges. Those allegations are one count of unlawful flight from a law enforcement vehicle, that's a Class 5 felony, and one count of drug paraphernalia possession, which is a Class 6 felony. I did find probable cause to support those new allegations, and I appointed a lawyer to defend you. Your next court hearings on those allegations will be a status conference April 2nd and then a preliminary hearing April 4th, both of those hearings at 8:30 in the Superior Court downtown. On those new allegations, you have a $15,000 secured appearance bond. The second matter that you're here on is a probation violation warrant. In that case, the allegation is that the allegation is that you have already violated terms 3 and 5 of your probation even prior to this new arrest. On the probation matter, I have appointed a lawyer to defend you. Your next court hearing in the probation case will be a revocation arraignment hearing April 3rd, also at 8:30 downtown. On the probation warrant, you are not eligible for release on bond. So you will be held in custody without bail at least until your probation hearing April 3rd. So I would encourage you to wait at least until after that hearing before attempting to post your bond on the new allegations. Do you understand that information?
Yeah.
Okay, thank you, sir. You can step back and get your paperwork. Okay. Paul Cardenas, if you would please work your way into the courtroom. Elijah Calderon, if I could ask you to work your way to that second chair. Okay, good morning. Can I have your name and date of birth, please?
Paul Cardenas, 2/19/1980.
Thank you very much, Mr. Cardenas. You are here on a grand jury warrant. A state grand jury was convened and found probable cause to return an indictment against you. That indictment contains one count of dangerous drug possession for sale, one count of narcotic drug possession for sale, both of those are Class 2 felonies, and one count of drug paraphernalia possession, which is a Class 6 felony. According to that warrant, those offenses are all alleged to have been committed September 19th of 2024. I have appointed a lawyer to defend you in that case. Your next court hearing will be an arraignment hearing April 3rd. It will be at 8:30 in the morning in the Superior Court downtown. And on that warrant, you have a $100,000 cash-only bond. If you post that bond and you are released from custody, you cannot possess any weapons or any drugs without a valid prescription. Do you understand those conditions?
Yes.
Okay, thank you, Mr. Cardenas. You can step back and get your paperwork.
I have a question.
Sure.
Is it okay? I'm already here on a bond from my other case. This is page 2. Is it necessary that they put a $100,000 cash bond on me for this case?
So when judicial officers are looking at setting bonds, so when the judge that issued this warrant set that bond, they're looking at the nature of the allegations in the specific case. They're looking at the nature or risk of harm posed by those allegations. They're not necessarily looking at whether or not you're held on bond in other cases. So the bond that was set, now I don't know specifically what facts that judge had because I didn't see the grand jury presentation, but I guess what I'm trying to say is I don't think that judge said he's being held on a bond, let's get this one a super high bond. I think that judge was probably looking at the facts of this case and found that a $100,000 cash bond on these facts was what was necessary and appropriate in this particular case.
Okay, so when I go and see the judge for the arraignment, will I be able to ask him to,
To change that?
Yeah.
You can ask your lawyer. So I would say when you get to that hearing, if that's something that you want done, if you want this reduced, talk to your lawyer. Tell your lawyer why you'd like to see that reduced. Talk to that about your lawyer, and your lawyer will determine whether or not that's an appropriate motion to make to the judge at that time.
Okay, thank you very much.
Okay, you're welcome. Go ahead and step back and get your paperwork. Apollonio Alvarez, if you would please work your way into the courtroom. Rafael Buckner, if I could ask you to work your way to the second chair, please. Can I have your name and date of birth, please, sir?
Apollonio Alvarez Jr.
And what's your date of birth, sir?
12/13/94.
Did you say 84 or 94?
Yes,
84. Okay, thank you, Mr. Alvarez. You are here on allegations of new charges. The allegations against you are 2 counts of aggravated assault. They are both Class 3 felonies. I have found probable cause to support both of those allegations. I have appointed a lawyer to defend you. Your next court hearings will be a status conference April 2nd and then a preliminary hearing April 4th. Both of those hearings will be at 8:30 in the morning in the Superior Court downtown. On these allegations, I have imposed a $50,000 secured appearance bond. Secured appearance means that you can use a bonding company to post that bond if you choose to. If you do post that bond and you are released from custody, you cannot go back to the location where these events took place. You cannot have contact with any alleged victims, and you cannot possess any weapons, any drugs without a valid prescription, or any alcohol if you're released from custody. Do you understand those conditions? Okay, thank you, Mr. Alvarez. You can step back and get your paperwork. Yes. It's here. Good. Okay, can I please have Elijah Calderon into the courtroom? Robin Roosh Wombles, if you would work your way to the second chair, please. Can I have your name and date of birth, please, sir?
Elijah Calderon, 02/12/06.
Thank you, Mr. Calderon. You are here on allegations of new charges. The allegations against you are 1 count of aggravated robbery, that is a Class 3 felony, and 1 count of aggravated assault on a first responder, a Class 6 felony. I have found probable cause to support those allegations, and I appointed a lawyer to defend you. Your next court hearings will be a status conference April 2nd and then a preliminary hearing April 4th. They will both be at 8:30 in the Superior Court downtown. On those allegations, I have imposed a $50,000 secured appearance bond. If you post that bond and you are released from custody, you cannot return to the scene where the alleged events took place. You cannot have contact with any alleged victims, witnesses, or co-defendants, and you are prohibited from possessing or consuming any alcohol or drugs without a valid prescription if you're released. Do you understand those conditions?
Yes.
Okay, thank you, Mr. Calderon. You can step back and get your paperwork. Raphael Buckner to the podium in the courtroom, please. Ronnie Shamoon, if you would please work your way to the second chair. Can I have your name and date of birth, please, sir?
Raphael K. Buckner, 04/18/1961.
Thank you, Mr. Buckner. You are here on allegations of new charges. The allegations against you are 1 count of aggravated assault, a Class 3 felony, 1 count of possession of a weapon by a prohibited person, a Class 4 felony, and 1 count of disorderly conduct involving weapons. That last one is a Class 6 felony. I have found probable cause to support these allegations, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference April 2nd and then a preliminary hearing April 4th. Both of those hearings will be at 8:30 in the Superior Court downtown.
Okay.
On these allegations, I have imposed a $25,000 secured appearance bond. Again, secured appearance means you can use a bonding company.
Okay.
If you do post that bond and you're released from custody, you cannot have contact with any alleged victims or witnesses, and you are prohibited from possessing any weapons if you're released from custody.
Okay.
Do you understand those conditions?
Yes, Your Honor.
Okay, thank you, Mr. Buckner. You can work your way back to your left. He'll get you your paperwork. Robin Roosh Wombles to the podium in the courtroom, please. Emmanuel Soto, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Robin Rush Wombles,
And what's your date of birth?
11/14/1991.
Thank you very much. You are here on a probation violation warrant issued by the Yavapai County Superior Court. I don't know whether Yavapai County has determined you're entitled to a court-appointed lawyer or not. If they have and you've been given a lawyer, that lawyer will still continue to represent you. If that determination has not yet been made, it will be made by the Yavapai County judge at your next court hearing. That hearing will be an arraignment hearing April 1st. It'll be at 8:30 and it'll take place in the Yavapai County Superior Court. On that warrant, you have a $25,000 secured appearance bond. If you post that, you will be eligible for release from custody, and then that will mean it will be your responsibility to get yourself to your hearing in Yavapai County on April 1st. Also, if you post that and you're released, in addition to getting to that hearing, you are ordered not to possess any weapons or any drugs without a valid prescription. Do you understand those conditions?
Is Yavapai County going to come get me?
If you don't post that bond and you're still in custody, yes, Yavapai County will come get you and take you to that hearing. Any other questions?
No, ma'am.
Okay, thank you very much. You can step back and get your paperwork. Ronnie Shamoon to the podium in the courtroom, please. Guy Hepworth, if you would please work your way to the second chair. Can I have your name and date of birth, please, sir?
Ronnie Shamoon, March 16, 1969.
Thank you very much, Mr. Shamoon. You are here on 3 different matters. The first matter that you're here on is an allegation of a new charge. That allegation is 1 count of dangerous drug possession for transportation or sale. It is a Class 2 felony. I have found probable cause to support that allegation, and I have appointed a lawyer to defend you. Your next court hearings will be a status conference April 2nd and then a preliminary hearing April 4th, both of those at 8:30 in the Superior Court downtown. On that new allegation, I have imposed a $15,000 secured appearance bond. The other 2 matters you're here on are both allegations that new charge violated Term 1 of your probation. In each of those 2 probation cases, I've appointed a lawyer to defend you. Your next court hearing in those 2 matters will be a revocation arraignment hearing April 3rd at 8:30 in the Superior Court downtown. On each of the 2 probation matters, you have a $5,000 secured appearance bond. That means your total bond for all 3 cases will be $25,000, all secured appearance. If you post that and you are released, you are ordered not to possess any weapons or any drugs without a valid prescription. Do you understand those conditions?
Yes.
Okay, thank you, Mr. Shamoon. You can step back and get your paperwork. Emmanuel Soto to the podium in the courtroom, please. Ryan Chi, if you would please work your way to the second chair. Can I have your name and date of birth, please, sir?
Emmanuel Soto, July 9, 2006.
Thank you, Mr. Soto. You are here on a grand jury warrant. A state grand jury was convened and found probable cause to return an indictment against you. The indictment in this case contains 1 count. It is unlawful flight from a law enforcement vehicle, a Class 5 felony, alleged to have been committed August 19th of 2024. I have appointed a lawyer to defend you against that allegation. Your next court hearing will be an arraignment hearing April 3rd. It'll be at 8:30 in the morning in the Superior Court downtown. And on that warrant, you have a $10,000 secured appearance bond. If you post that and you are released, you are ordered not to possess any drugs without a valid prescription, and you cannot operate a motor vehicle if you don't have a valid driver's license. Do you understand those conditions?
Yes, ma'am.
Okay, thank you, Mr. Soto. You can step back and get your paperwork.
I have a question.
Okay.
Are both of my bonds secured?
So the only bond I know about is this one, is the $10,000 one, and it is secured. Are you being held in another matter on another bond?
I have two bonds. I'm pretty sure.
Already, in addition to this one?
No, just two in total.
This one and one other?
Yeah.
So is the other on a new possession of a weapon by a prohibited person charge?
No, it's old. That was the one I originally had.
You were seen in August on that?
Yeah, I was arrested in August 2024.
Okay. Do you know what the allegation is in the other case you're being held on a bond on?
A gun charge.
Okay. For the gun charge you were arrested in August on?
Yes.
Has the bond that was issued in that case when you came through this court ever been modified?
I don't know.
You don't know. So it looks like when you came through here, the bond on that case was a $10,000 cash bond, but I don't know what may have happened between when that was imposed in August and now. So I can't say that's still the bond applicable to that case, but it looks like at least when it was originally, when those conditions were originally imposed, that was a cash-only bond.
Okay.
So if you think it may have been changed, you can talk to your lawyer. MCSO might know what bond you're being held on in that case, so you could ask jail staff. Otherwise, talk to your lawyer. Your lawyer will know whether that bond has been changed or not. But it looks like you have a $10,000 cash bond and then this $10,000 secured bond.
Okay.
Anything else?
No, ma'am. Thank you.
Okay, thank you very much. You can step back and get your paperwork. Guy Hepworth to the podium in the courtroom, please. James Shivers, if you would work your way to the second chair, please.
Good morning, Your Honor.
Good morning. Can I have your name and date of birth?
My name is Guy Hepworth, 12969, ma'am.
Thank you very much, Mr. Hepworth. You are here on allegations of new charges. The allegations against you are 1 count of criminal trespassing in a residential structure. That's a Class 6 felony. 4 counts of criminal trespassing in a residential yard. Those are all Class 1 misdemeanors. And 1 count of animal cruelty. That's also a Class 1 misdemeanor. I have found probable cause to support those 6 allegations. I have appointed a lawyer to defend you. Your next court hearings will be a status conference April 2nd and then a preliminary hearing April 4th. Both of them will be at 8:30 in the morning in the Superior Court downtown. On these allegations, I have imposed a $10,000 secured appearance bond. If you post that bond and you are released from custody, you cannot return to the scene where any of the alleged trespassing offenses took place. You cannot have contact with any alleged victims or witnesses. You cannot possess any weapons or drugs without a valid prescription. And so long as this case remains pending, you are also prohibited from possessing any domestic animals. Do you understand those conditions?
Yes, ma'am.
Okay.
If I could, the officer had asked me to briefly explain the situation. I'm
going to encourage you not to because you don't have a lawyer in
I would
here.
appreciate it if I could, just to explain the situation. I understand my rights and everything, and I just would like to explain it.
Okay.
So I was at a job, and I walked to my house. I was in the process of moving out of the house and going into New Hope. There was a bed not available. I spoke to the lady at the coordinator of New Hope. I was supposed to contact her yesterday. I was sort of in the middle of getting arrested and everything else. Needless to say, that would be where I go today if you would release me on an ROR. I have my truck and everything. I own my own business. I cut trees down. Every neighbor in that cul-de-sac where I live, outside past the fire department, is my customer. All my equipment is lined up on the side of the gentleman's house that I was supposed to be finishing up that day. My truck was towed. I went back to the house because I had been informed that the owner of the house was there, as well as a dump truck. So they were going to remove all my property. I presented myself to Sandra, the owner of the house, and asked her, can I please get a bag that has my wallet, my father's pictures from 1950 in the Air Force? She refused. The officer had gone, he gave me 5 minutes to go in and get possessions. I went in, cleared as much as I can, and in the process of arguing with Miss Henson and everything else, I left that one box behind. Stupid me, instead of just asking the officer, can I go back in the home? No, I took it upon myself, and I did go in the home and get that bag because of the possessions and the sentimental value of it alone. That's the only reason I went in that home. Otherwise, I would never have gone nowhere near it, knowing the facts. I've been here 1 year, roughly. All I've done is work. I renovated that lady's house completely, inside and out, and she's suing me for $11,000 now that the house is fixed. Needless to say, I work every day. I work hard. I also have an opportunity to go to New Hope. I've been off my medication since my mom passed. It's a little sketchy, but I would like to be able to go to this New Hope today or tomorrow, available with my sister. I would stay with my sister in Ahwatukee, far away from wherever this happened, and then be able to go to New Hope tomorrow and be able to get all my medications, everything I need to get my mind right. I'm a hard-working person, and I don't want to do nothing but work, but the incident that happened yesterday was upon me. I could have just asked the officer, but knowing the fact that all that stuff was in there just meant so much, more than the fact of getting arrested.
Okay,
so I apologize for that.
I hear you, Mr. Hepworth. I understand that things may have happened yesterday that you wish had not happened, but we can't change the circumstances on why you're here.
Exactly.
And so here's the reason that bond is being imposed. Well, partially it's based on your criminal history, and my records indicate that you have 23 prior felony convictions. What that means is, based on these new allegations in light of your past criminal history, the court feels strongly that a bond is necessary in order to protect the public. I hear you saying that this was potentially a one-off situation based on some emotional response to getting your
If you look at the last arrest, I've been clean and sober for that long, and unfortunately, like I said, I got off my meds and things went on go left field.
And in order to prevent that from continuing or snowballing, that's part of the reason that bond is being imposed. So you will have to post that bond in order to be eligible for release. I will tell you, Mr. Hepworth, that if there is medication that you need to be taking that you're not, if you do not post that bond and you stay in MCSO custody, it is their responsibility to ensure for your medical care. So to the extent you don't get that bond posted and you stay in custody, make sure you communicate to jail staff what, if any, medical needs you have so that they can make sure that your medical needs are provided for.
And as far as bond, that's a $10,000 cash secure bond?
It's a $10,000 secured bond, so you have the opportunity to use a bonding company. If you want to explore that option, there's a list of bonding companies and their phone numbers back in the facility. You can find that list and use any phone as soon as you get back.
I appreciate the time.
Okay, thank you, sir. You can step back and get your paperwork. Ryan Chi to the podium in the courtroom, please. Eric Ailman, if you would please work your way to that second chair. Can I have your name and date of birth, please, sir?
Ryan Roy Chi, 4/26, 1982.
Thank you, Mr. Chi. You are here on allegations of new charges. The allegations against you are 1 count of burglary, a Class 4 felony, and 1 count of criminal trespassing, a Class 3 misdemeanor. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference April 2nd and then a preliminary hearing April 4th. Both of those will be at 8:30 in the morning in the Superior Court downtown. On those allegations, I have imposed a $2,500 secured appearance bond. If you post that and you are released from custody, you cannot return to the scene where the underlying events took place, and you cannot have contact with any alleged witnesses. Do you understand those conditions?
Yes.
Okay, thank you, Mr. Chi. You can step back and get your paperwork. James Shivers to the podium in the courtroom, please. Lorraine Arvalo, if you would please work your way to the second chair. Can I have your name and date of birth, please, sir?
James Samson Shivers, birthday 11/18/2003.
Thank you very much. Your last name is pronounced Shivers?
Yeah.
Okay, I'm sorry, Mr. Shivers. You are here on a grand jury warrant. A state grand jury was convened and found probable cause to return an indictment against you. That indictment contains 2 counts. The first is armed robbery, a Class 2 felony alleged to have been committed September 11th of 2024. The second is 1 count of organized retail theft, a Class 4 felony alleged to have been committed September 9th of 2024. I have appointed a lawyer to defend you against these allegations. Your next court hearing will be an arraignment hearing April 3rd at 8:30 in the Superior Court downtown. And on that grand jury warrant, you have a $500 secured appearance bond. If you post that and you are released, in addition to getting yourself to your next court hearing, you are ordered not to return to the scene where any of the underlying events took place. You also cannot have contact with any alleged victims or witnesses of the underlying allegations. Do you understand those conditions?
Yes.
Okay, thank you very much, Mr. Shivers. You can step back and get your paperwork. Eric Ailman to the podium in the courtroom, please. Patricia Jones, if I could ask you to work your way to the second chair. Can I have your name and date of birth, and will you pull your arms out of your shirt?
Yes, ma'am.
Thank you very much.
My name is Eric Alaman. My birthday is 05/13/1995.
Thank you very much, Mr. Alaman. You are here on 4 probation violation warrants. In each of the 4 cases, the warrants were issued by the probation court when you failed to appear at a revocation arraignment hearing. In all 4 of those cases, you already have a lawyer assigned to represent you. That lawyer will continue to defend you. Your next court hearing in each of these 4 cases will be a new revocation arraignment hearing. It will take place April 3rd at 8:30 in the probation court downtown. On each of the 4 warrants, you have a $500 secured appearance bond. That means your total bond will be $2,000. It is all secured appearance. If you post that and you're released from custody, in addition to getting to your next court hearing, you are ordered not to possess any weapons or any drugs without a valid prescription. Do you understand those conditions?
Yes, ma'am.
Okay, thank you, Mr. Allman. You can step back and get your paperwork. Lorraine Arvalo to the podium in the courtroom, please. Nicolette Tatum, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Lorraine Arvalo, and it's April 22nd, 1979.
Thank you very much. You are here on a bench warrant issued by the Superior Court when you failed to appear at a sentencing hearing in an existing felony burglary and trespassing case. You have a lawyer assigned to you in that case already. That lawyer will continue to defend you. Your next court hearing will be a status conference April 2nd. It'll be at 8:30 in the morning in the Superior Court downtown. And on that warrant, you have a $500 secured appearance bond. If you post that and you're released from custody, you are ordered not to possess any drugs without a valid prescription. And you're also ordered not to return to the scene where the underlying trespassing allegation took place or to have any contact with alleged victims of the burglary allegation. Do you understand those conditions? Okay, thank you. You can step back and get your paperwork.
So, do I get released, or?
You have a bond. If you post that bond, you're eligible for release. Patricia Jones to the podium in the courtroom, please. Dominic Lopez, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Patricia Jones, 12/23/62.
Thank you very much, Ms. Jones. You are here on a probation violation warrant. A petition to revoke your probation was filed. It alleges that you have violated terms 3, 4, 5, and 15 of your probation. I've appointed a lawyer to defend you. Your next court hearing will be a revocation arraignment hearing. It'll be April 3rd at 8:30 in the probation court downtown. On that warrant, you have a $250 secured appearance bond. If you post that and you are released, you cannot possess any weapons or any drugs without a valid prescription. Do you understand those conditions?
Yes.
Okay, thank you, Ms. Jones. You can step back and get your paperwork. Nicolette Tatum to the podium in the courtroom, please. Samantha Schneider, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Nicolette Tatum, 12/29/1989.
Thank you, Ms. Tatum. You are here on 4 probation violation warrants. In all 4 cases, petitions to revoke your probation have been filed. Each of the 4 alleges that you have violated terms 3 and 5 of your probation. I have appointed a lawyer to represent you in all 4 cases. Your next court hearing in each of these cases will be a revocation arraignment hearing. It will be April 3rd at 8:30 in the Superior Court downtown. On these 4 warrants, you have a total secured appearance bond of $850. It is $250 on 3 of the 4 warrants and $100 on the 4th. So again, total is $850. It is all secured appearance. If you post that and you are released from custody, you are ordered not to possess any weapons or any drugs without a valid prescription. Do you understand those conditions?
Yes.
Okay, thank you, Ms. Tatum. You can step back and get your paperwork. Dominic Lopez to the podium in the courtroom, please. Larisha Wallace, if you would please work your way to the second chair. Can I have your name and date of birth, please, sir?
Dominic Michael Lopez, 09/24/1995.
Thank you, Mr. Lopez. You are here on 2 probation violation warrants. In both of your cases, petitions to revoke your probation have been filed, alleging that you have violated terms 3, 5, and 15. I have appointed a lawyer to defend you. Your next court hearing in both of these cases will be a revocation arraignment hearing, April 3rd at 8:30 in the probation court downtown. On each of these 2 warrants, you have a $100 secured appearance bond. So your total bond will be $200. It is all secured appearance. If you post that and you're released from custody, you are ordered not to possess any weapons or any drugs without a valid prescription. Do you understand those conditions?
Yes, I understand.
Okay, thank you, Mr. Lopez. Samantha Schneider to the podium in the courtroom, please. Darius Johnson, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Samantha Schneider, September 30th, 1980.
Thank you, Ms. Schneider. You are here on a bench warrant issued by the Superior Court when you failed to appear at a status conference in an existing felony drug case. You have a lawyer already assigned to you in that case. That lawyer will continue to defend you. Your next court hearings will be a new status conference April 2nd and then a preliminary hearing April 4th. Both of those hearings will be at 8:30 in the morning in the Superior Court downtown. On that warrant, you have a $250 secured appearance bond. If you post that bond and you are released from custody, in addition to getting yourself to both of your next court hearings, you are ordered not to possess any drugs without a valid prescription. Do you understand those conditions?
So, I've never had a bond before, so I have to pay $250?
You have to post a bond of $250 to be eligible for release, yes.
Is not a percentage of that or anything?
It is secured appearance. That means you can use a bonding company. That percentage is something, that's a requirement or a condition imposed by a bonding company, not by the court. So if you want to explore going through a bonding company, you can find a list of companies and their phone numbers back in the jail, and you can start calling them anytime you want to see what their requirements might be.
There's no way I could be released on my own recognizance?
No, because the last time you were on release, you didn't appear at your court hearing. So that bond is the court's assurance that you'll make your next hearing. And if you think you have a justification or a reason for not making that hearing, I encourage you to share that with your lawyer. It doesn't change the fact that you have to post a bond to be eligible for release at this hearing this morning. Any other questions, Ms. Schneider? Okay, thank you very much. You can step back and get your paperwork. Larisha Wallace to the podium in the courtroom, please. Marche Richardson, if you work your way to the second chair. Can I have your name and date of birth, please?
Larisha Wallace, April 16, 1992.
Thank you, Ms. Wallace. You are here on an allegation of a new charge. The allegation against you is 1 count of criminal trespassing. It is a Class 6 felony. I have found probable cause to support that allegation and appointed a lawyer to defend you. Your next court hearings will be a status conference April 10th and then a preliminary hearing April 14th. Both of those hearings will be at 8:30 in the morning in the Superior Court downtown. On that allegation, I am releasing you to the supervision of pretrial services. What that means, Ms. Wallace, is you will be released from custody. You do not need to post a bond. However, once you are released from custody, you will be required to make contact with pretrial services. Their contact information will be in a packet that you get with your release order, so please keep that so you have their phone number. Once you're out of custody, in addition to calling pretrial, you will be responsible for getting yourself to both of your next court hearings, and you cannot go back to the scene where you were allegedly trespassing. Do you understand all of those conditions?
Yes, ma'am.
Okay, thank you, Ms. Wallace. You can step back and get your paperwork. Darius Johnson to the podium in the courtroom, please. Cody Bishop, if you would please work your way to the second chair. Can I have your name and date of birth, please, sir?
Darius Johnson, March 21st, 1990.
Thank you, Mr. Johnson. You are here on allegations of new charges. The allegations against you are 1 count of disorderly conduct, a Class 1 misdemeanor, and 1 count of assault, a Class 3 misdemeanor. I have found probable cause to support those allegations. I've also determined you are entitled to a court-appointed lawyer. That lawyer will be appointed for you by the next judge you see at your next court hearing. That hearing will be an arraignment hearing April 15th. It will be at 2 o'clock in the afternoon in the Buckeye Municipal Court. I am releasing you on your own recognizance on these allegations. Once you are released from custody, in addition to getting yourself to that hearing April 15th, you are also ordered not to have contact with the alleged victim or any alleged witnesses of the underlying allegations. You also cannot possess any weapons, and you cannot possess or consume any alcohol or drugs without a valid prescription once you're out of custody. Do you understand those conditions?
Yes, but I also have a question.
Sure.
So I was told by like the officers and one of the interviewer guys to ask you if I could get permission to, because where the incident happened was in my home.
I'm not prohibiting you from going back there. So my understanding of the facts is that the alleged victim does not reside at that location. Is that accurate?
So I don't know y'all law. So the way it was explained to me was that since she had mail there, she was a resident, and so she is a resident.
But does she live there?
She was living there with me, and then after, so once they locked me up or whatever, put me in jail, I guess something else happened to where she couldn't go back there. So that's when they told me to ask you if I could get permission to go back to my home because she can no longer go there for the moment.
I'm not prohibiting you from returning to the scene where this occurred. So no condition of this court is that you can't go back there. The condition coming out of this court is that you can't have contact with that alleged victim. So okay. It's fine from this court for you to go home, but if the alleged victim then somehow comes back and starts living there, then you would have to leave because you can't have contact or be around her. So I'm not dictating where you go or where you don't go. I'm only dictating who you can have contact with.
Also,
so proceed with caution. I mean, go home, but if circumstances are not as you think they are right now and she's there and living there, then you should find somewhere else to live, at least until your first hearing on the 15th.
Okay, and also one more question. How should I go up, because we have kids together, so how should I go about that? Could I use my mother as a third party?
Yes. At least between now and the 15th, that's exactly what you should do. Assuming you have the ability to, you should have a friend, family member, somebody assist in communicating with her regarding the children or transferring the children if you have some arrangement where they need to go from you to her, her to you. Use your mother. If you have a friend, family member that could do that, you can do that. No prohibition on you having contact with your children.
Okay.
Anything else?
No.
Okay, thank you very much, Mr. Johnson. You can step back and get your paperwork. Okay, Marche Richardson, if you would work your way into the courtroom, please. Alberto Buelna Inzunza, if you would work your way to the second chair. Can I have your name and date of birth, please?
Marche Richardson, 6/29/93.
Thank you very much, Ms. Richardson. You are here on allegations of new charges. The allegations against you are 1 count of assault and 1 count of disorderly conduct. They are both Class 1 misdemeanors. I have found probable cause to support those allegations. I've also determined you are entitled to a court-appointed lawyer. That lawyer will be appointed for you by the next judge you see at your next court hearing. That hearing will be an arraignment hearing April 15th. It will take place at 2 o'clock in the afternoon in the Buckeye Municipal Court.
Okay.
I am releasing you on your own recognizance, so you will be released from custody. Once you are out of custody, you cannot have contact with the alleged victim or victims of the underlying allegation, and you also cannot have contact with any alleged witnesses.
Okay.
You're also prohibited from possessing any weapons, drugs without a valid prescription, or alcohol once you're out of custody.
Okay.
Do you understand those conditions?
Yes.
Okay.
I do have some questions.
Okay.
Okay, so Darius Johnson that just left out of here. I'm the victim of Darius Johnson.
Okay.
We all live in the same home.
Okay.
So from my understanding, I cannot return, and I also have my kids because the initial, before I was put in here, I was being put into a hotel, me and my kids, for the night because of that. It didn't happen that way because I ended up getting into an argument with his sister, which led me here.
Okay.
I don't have any family or nothing here. I don't have no family here. I initially came out here with him. So how do that work out in my situation for me and my kids? I heard you say that his mom can have whatever rights it is with her, but...
No. I not give his mom any rights to the children. What I told him is that since you and him cannot have contact with each other, if you have some agreement where Monday, Tuesday, Wednesday, the kids are with you, Friday, Saturday, they're with him, since you can't contact each other, he can't come get the kids from you. His mom could drive in his car, get out of the passenger seat, hold the kids' hands, take them to the car. His mom can be the person that communicates between the two of you. I'm not giving mom any rights to the children. I'm only saying that mom can be the means of communication between the two of you since you cannot communicate with each other.
Got you.
In terms of who lives where, I'm not making any orders. I'm not telling anybody where they can or cannot live, but I am telling both of you that you can't have contact with each other. So you can't live in the same place. So one of you will have to reside somewhere else, at least until your first court hearing.
Okay, is there any resources I can do as far as for me and my kids to get us somewhere to stay? Because, again, I don't have no family that is his mom and siblings home, so I would be the one that can't return there.
So not provided by the court?
Yeah, just some type of resources that I can find out about.
It sounds like we have a list of resources for you, so stay right there. This officer will grab that, give it to you with your paperwork. I don't know what your phone situation is, but if you're given the opportunity to use a phone before you're released from custody, you can use that list and try and call and get that lined up before you're released. If not, once you're out of custody, use that list. It sounds like there's some resources there for you.
Okay.
Any other questions?
No.
Okay, thank you, Ms. Richardson. You can step back and get your paperwork. Okay, Cody Bishop to the podium in the courtroom, please. Counsel, you're for Morgado and Gonzalez, right? Yes. Okay, your two will be up next, but I think we're still waiting for an interpreter to connect. So you're coming up. Thank you for your patience. Okay, can I have your name and date of birth, please?
Cody Bishop, 01/14/1995.
Thank you very much, Mr. Bishop. You are here on an allegation of a new charge. The allegation against you is one count of disorderly conduct. It is a Class 1 misdemeanor. I have found probable cause to support that allegation, and I have determined that you are entitled to a court-appointed lawyer. That lawyer will be appointed for you at your next court hearing by the next judge you see. That hearing will be an arraignment hearing April 15th. It'll be at 9:30 in the morning in the White Tank Justice Court. I am releasing you on your own recognizance, so you will be released from custody. You don't need to post a bond. Once you are out of custody, you cannot have contact with any alleged victims or witnesses of the underlying allegation. You also cannot possess any weapons, and you cannot possess or consume any alcohol or drugs without a valid prescription. Last, you are strictly ordered to comply with the terms of any orders of protection, if any have been or are later served upon you. Do you understand those conditions?
Yeah, I did have a quick question.
Okay.
So we share 50-50 joint custody of the kids, and
who's we? You and alleged victim?
Me and their mother. The mother wasn't even really a victim. I was yelling at the police, and that's why they took me for disorderly, because I had called them for her assaulting me, and they told me that basically she wasn't going to be charged. I started yelling, and they ended up taking me. She put in the restraining order both of my children on there, but we have joint custody of them. And so I'm not sure how that works with moving forward.
So here's what I'll tell you. Any arrangement that alters custody or the terms of the orders of protection will have to be addressed by the issuing court. So what that means is if you're challenging or have issues with the order of protection, you have to go to the court that issued that order to get that cleared up. Okay. How that affects going forward a custody arrangement is something that you'll have to take up with the family court where that custody arrangement was established. Okay. What I'll tell you coming out of this court, though, is for now, you are ordered to comply with the terms of that order of protection if it's been served on you. Okay. So in the interim, comply with that order of protection unless and until you can seek legal advice and get it changed by the court that issued it.
Yes, ma'am.
Okay, anything else, Mr. Bishop?
No.
All right, thank you very much. You can step back and get your paperwork. Alberto Buelna Inzunza, if you'd work your way into the courtroom, please. Anything? Can I have your name and date of birth, please, sir?
Alberto Buelna Zunza, 03/23/95.
Thank you very much, sir. Okay, you are here on allegations of new charges. The allegations against you are 1 count of narcotic drug possession and 1 count of child or vulnerable adult abuse. They are both felony allegations. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference April 10th and then a preliminary hearing April 14th. They will both be at 8:30 in the morning in the Superior Court downtown. I am releasing you to the supervision of pretrial services. I'm also imposing a condition of weekly alcohol and drug testing and monitoring. So what that means is you will be released from custody. You don't need to post a bond, but once you are out of custody, you will be required to contact pretrial services to make arrangements for drug and alcohol testing. Their contact information will be in a packet that you get with your release order. Also, once you are released from custody, you are ordered not to return to the scene where the alleged events took place. You cannot have contact with any alleged witnesses, and you cannot have contact with any minors. Exception is you may have contact with your own minor children, but only if another adult over the age of 21 is also present. Also, you cannot possess any drugs without a valid prescription or any alcohol, and you cannot possess any weapons if you're released. Do you understand those conditions?
Yes, Your Honor.
Okay, thank you very much. You can step back and get your paperwork. Shall we just use language line?
I can. Do you want to see alcohol on the line?
Sure. Okay, number 28 on the calendar, Kendra Shanquel Turnoy. Date of birth, March 3rd, 1989, is not in the courtroom because she was unable to function in general population due to bizarre behavior. She is here on 5 different matters. The first is an arrest warrant issued after a direct complaint was filed. The allegation in that direct complaint is 1 count of theft of a means of transportation, a Class 3 felony. I appointed a lawyer to defend her in that case. Her next court hearings on the new allegation will be a status conference April 2nd and a preliminary hearing April 4th, both at 8:30. On the direct complaint warrant, she has a $50 cash-only bond. The second matter that she's here on is a failure to appear warrant issued by the Superior Court when she failed to appear at a trial management conference in an existing felony aggravated assault case. She already has a lawyer in that matter. Her next court hearing will be a post-warrant status conference April 10th at 8:30. On that warrant, she has a $10,000 cash-only bond. In that same case, she was also subject to a pretrial warrant for allegedly tampering with an electronic monitoring device or otherwise absconding from pretrial services. The court is taking no action on that warrant since Ms. Tenor is already being held on a cash bond in the same case on the failure to appear warrant. The third matter that she's here on, or I guess technically fourth matter, is a probation violation warrant. In that case, a petition to revoke her probation was filed. I've appointed a lawyer to defend her. Her next court hearing will be a non-witness violation hearing April 3rd at 8:30. On that warrant, she has a $50 cash-only bond. The last matter she's here on is a grand jury warrant. A grand jury indictment was issued alleging 1 count of burglary, a Class 4 felony, 1 count of possession of burglary tools, a Class 6 felony. I appointed a lawyer to defend her in that case. Her next court hearing will be an arraignment hearing April 3rd. In that matter, because the alleged events occurred while she was on felony release, she is not eligible for release on bond. She will be held in custody without bail, at least until an evidentiary hearing is held. The evidentiary hearing in that case will be April 3rd at 1:30. If anything changes after I visit her cell side, the court's final orders will be reflected in her written release orders. Okay, let's get people lined up then. Counsel, you're up next. I'm told an interpreter is connecting shortly. I will take Mr. Morgada first. Mr. Morgada, if you would work your way into the courtroom, assuming you understand. Thank you, sir.
Yeah. He sees me.
Okay, if you'll give us 1 minute, we're waiting for an interpreter.
And I spoke to the prosecutor earlier. I don't know if he's coming in.
I don't think he is.
Okay. There's kind of a weird thing going on with this one.
It looks like it.
Okay. I can explain it when we go.
I think I know some, but...
Okay. I guess tell the clerk now too, his name is misspelled. I think you guys have Leodys. It's Leonys.
I have Leonys.
Oh, perfect.
On the warrant, it is Leod. I'm not sure it matters too much if this is ultimately going to get dismissed, but it looks like in our record it is spelled correctly.
Okay, perfect.
Officer, do I still have 2 in the gallery? Yeah. Okay. I only see 1 head, that's why I was asking.
Oh, there's one tucked
okay.
There. I see an off-chain one as well.
What?
Does he an off-chain one as well?
Yeah.
Okay.
What did they say? Did they say we're connecting right now?
Yeah. Response from the evaluation.
¿Entiende inglés? No. No suficiente.
No suficiente.
Okay. Esperamos.
So I would say let's just try and call language line. If we get them before we get her, then respond and say thanks, we need this one sooner.
Es que a veces entiende suficiente para tratar de hacerlo, pero si no, está bien.
Pero como yo no puedo hablar ni nada.
No, está bien. Esperamos.
My apologies, gentlemen. We thought we had an interpreter lined up, and so we're working on it.
That's okay, Judge.
The luxury of being downtown is they can just run down and get one.
I know. Yeah.
Sorry, my language.
No, está bien. ¿Y dónde es?
Yo, en Cuba. Ah, sí, yo entiendo bastante, pero como para...
No sabía si en Cuba
o dominicano. Sí, similar. A veces se confunden. Sí.
So that one's cut out, but we just got a response, say Jennifer will be connecting soon.
Okay.
Did you want to wait?
Yeah, well, soon, like right now. Do they know that we're ready for them right now? Okay.
Ojalá que no. Does the other off-chain one need the interpreter too?
No, but the courtroom has to be clear.
Yeah.
I think we have an interpreter coming right now. I don't want to move him around and make him leave and come back. And...
No problem. Me dejan la última.
No interpreter?
We're getting one.
You want me to do it?
No, thank you. Appreciate that. Hi, good morning, Madam Interpreter. Are you able to hear us?
Yes, I can. Good morning.
Okay, very good. If you would please make your announcement for the record, we are ready to get started with the interpretation.
Jennifer Hammond, court interpreter.
Thank you very much, Ms. Hammond. Okay, and I have two matters that I require your assistance with. We've got the first one in the courtroom, and we are ready to begin if you are ready.
I'm ready.
Okay, good morning, gentlemen. First, let me thank you both for your patience. I know it took a while to get an interpreter. I apologize for that. Thank you again for your patience.
Buenos días, señores. Gracias por su paciencia. Yo sé que tardó un rato para que llegara un intérprete y agradezco su paciencia.
Okay, Mr. Morgado, could I ask you to please give me your full name and date of birth?
Señor Morgado, por favor diga su nombre completo y fecha de nacimiento.
Leonis Rojas Morgado, junio 5 de 1980.
Leonis Morgado, ¿qué dijo?
Rojas Morgado.
Rojas Morgado, 6580.
Thank you very much, Mr. Morgado. An appearance of counsel, please.
Good morning, Your Honor. Mark Mendoza on behalf of Mr. Morgado, who's present to my left, being assisted by the court interpreter.
Mark Mendoza, representando al señor Morgado, presente a mi lado izquierda con la ayuda de la intérprete.
Good morning. Thank you for being here, Mr. Mendoza.
No problem.
Buenos días. Gracias por estar aquí, señor Mendoza.
Okay, Mr. Morgado, I am seeing you this morning on a grand jury warrant.
Señor Morgado, está compareciendo usted hoy por una orden de aprehensión del jurado indagatorio.
It looks like the grand jury indictment contains one count of armed robbery, one count of theft of a means of transportation, both from February of 2025.
El informe de los cargos del jurado indagatorio tiene dos capítulos, acusaciones a robo armado y el robo de medio de un transporte. Los dos son del febrero del 2025.
It is my understanding, based on a draft motion to quash and dismiss filed by the state, that you were already served for these same charges in a different case number.
Tengo entendido, según el pedimento del Estado para cancelar y desestimar, que ya le habían dado notificación de este caso con un otro número de caso.
Because this court is not a court of record, I cannot sign that order and dismiss this case.
Como este juzgado no es un juzgado de actas, yo no puedo firmar esa orden y desestimar este caso.
So what I'm going to do is release you from custody on this warrant.
Entonces, lo que voy a hacer es ponerlo en libertad por esta orden de aprehensión.
Out of this court, you will also have a next court date on this warrant, assuming that the underlying judge doesn't dismiss this before.
En este juzgado se le va a fijar otra audiencia. En este caso, eso suponiendo que el juez de su caso no lo desestime antes.
That hearing will be an arraignment hearing April 3rd at 8:30.
Esa audiencia será una vista ventilatoria el 3 de abril a las 8:30.
And it doesn't sound like this case on this case number is going to proceed, but if it does, you're entitled to a court-appointed lawyer.
Parece que este caso con este número no va a proceder, pero si procediera, usted tiene derecho a que el juzgado le nombre a un abogado.
You have the right to proceed with Mr. Mendoza or any other private lawyer. However,
usted tiene derecho de proceder con el señor Mendoza o cualquier otro abogado privado. Sin embargo,
if no arrangement is made between you and a private lawyer, you are entitled to a public defender.
Si no hiciera un arreglo con un abogado privado, usted sí tiene derecho de tener un defensor de oficio.
Okay, Mr. Mendoza, feel free to tell me what I'm getting wrong, see what else we need to address. The floor is yours.
Señor Mendoza, que me diga si me estoy equivocando o si hay algo más de que tenemos que hablar. Ahora puede hablar usted.
I just wanted to clarify, I know you can't rule on it right now. Did the county attorney file a motion to dismiss this new CR? or the old one?
Sé que usted no puede fallar sobre este experimento en este momento, pero quería preguntar que si la Fiscalía ha entablado el experimento para desestimar este caso, número de caso, o el anterior.
The proposed motion and order that was sent to me, signed by Elizabeth Lake, is filed under this CR.
El pedimento y orden propuestos que interpuso la fiscal Elizabeth Lake está pidiendo desestimar este número de caso.
In the body of it, it does say moves to dismiss CR 2025-006528, which is this case, without prejudice, and references CR 2025-108-539, which I think is the other case.
En el pedimento menciona que el Estado pide desestimar el caso 2025-006-528 y menciona que piensan proceder con el otro número de caso 2025-108-539.
Do you want a copy of that proposed motion and order?
I would love
¿Quiere
that.
tener una copia de ese pedimento y orden propuestos? Me encantaría.
And then, can I ask a follow-up question?
¿Puedo hacer otra pregunta?
That motion was filed, do you know who it was filed? Because you can't rule on it, right?
That's
so
right.
It needs to be a superior...
¿Sabe quién
Sorry,
lo
Madam Interpreter.
interpuso? Usted no puede firmarlo, ¿verdad?
That I don't know, and I honestly don't know whether it's actually been submitted for filing by an actual clerk that can accept it.
Eso no sé. Y no sé en realidad si se haya interpuesto ante un actuario que en realidad puede archivarlo.
The mailing certificate just says that it was emailed, e-filed with this court.
El certificado de envío simplemente dice que se mandó por correo electrónico para archivar en este juzgado.
But we can't e-file it, so it will get uploaded in the initial appearance documents, but I highly doubt that will cue any judge to rule on it.
No, entonces no podemos archivarlo electrónicamente en este juzgado, pero sí se subirá al sistema, pero no creo que un juez se dé cuenta para poder tomar una decisión.
So I would probably encourage you to communicate either with Ms. Lake or the division where this ultimately gets assigned so that that court can take some action on this motion.
Entonces, lo que le sugiero es que esté en comunicación usted con la Suite Lake o con el juez a donde se mande el caso para que el juez pueda fallar sobre este experimento.
Okay.
What else, Mr. Mendoza?
I'll follow up with the prosecutor to make sure they file it with the court over there. I say Superior Court, so it can be actually dismissed. And so my client understands.
Voy a comunicarme con la fiscal para que interponga el pedimento ahí en el Tribunal Superior para que el juez pueda desestimarlo.
And just so my client understands, once another court dismisses this case, you then should be released.
Y para que entienda mi cliente, una vez que otro juez o juzgado desestime el caso, entonces debe de estar en libertad. ¿Así es?
He's going to be released right now.
Él va a ser puesto en libertad ahora mismo.
Okay.
So I'm going to release him on this warrant under the assumption that it will be quashed and the case will be dismissed.
Okay,
Lo voy a poner en libertad con este orden de aprehensión con la suposición de que se va a desestimar el caso.
It's just that while between now and when it's formally dismissed, he'll have to go back to court and comply with release conditions.
Solo que entre ahora y el momento que se desestime formalmente, él tendrá que volver a una audiencia y cumplir con sus condiciones de libertad.
Okay. Anything else, Mr. Mendoza?
No, Your Honor.
¿Algo más, señor Mendoza? No, señora, gracias.
Okay. Thank you both very much. Mr. Morgado, you are free to step back to your left. We will get your lawyer a copy of your paperwork.
Puede pasar a su lado izquierda. Su abogado va a recibir la copia de su papel, señor.
Okay. Officer, if you would please, can he go all the way out? And then can I please have Luis Gonzalez into the courtroom? Okay, are we ready? You ready? Okay.
Sorry. You can go, Judge. You can start.
Okay, Mr. Gonzalez, can I ask you to please state your full name and date of birth?
Señor González, por favor, diga su nombre completo y su fecha de nacimiento.
Luis Antonio González, mi fecha de nacimiento es enero 17 de 1962.
Luis Antonio González, my birthday is January 17, 1960. ¿60 y qué dijo? 62.
62.
Thank you very much, Mr. Gonzalez. And I understand I have lawyers appearing for both sides in this case.
Muchas gracias, señor González. Y tengo entendido que hay abogados que van a comparecer por ambos lados de este caso.
The state's lawyer, I believe, is appearing virtually. Assuming that's true, can I please have the appearance of counsel for the state after the translation?
La fiscal está compareciendo virtualmente, parece, y si es así, que la fiscal diga su nombre después de la interpretación.
Good morning, Your Honor. Sam Hart on behalf of the state.
Buenos días, su señoría Sam Hart, de parte del Estado.
Good morning, Ms. Hart. Thank you for joining us. Okay, appearance of counsel. Sorry.
Buenos días, señorita Hart. Gracias por estar aquí. ¿Es el abogado que comparezca?
Appearance of counsel for the defendant.
El abogado del acusado.
Mark Mendoza on behalf of Mr. Gonzalez.
Mark Mendoza, de parte del señor González.
Thank you very much, and thank you also again for being here, Mr. Mendoza.
Muchas gracias. Gracias por estar aquí también, señor Mendoza.
Okay, Mr. Gonzalez, you are here on allegations of new charges.
Señor González, usted está aquí por acusaciones de cargos nuevos.
Those allegations are one count of sex conduct with a minor alleged to be a Class 1 felony.
Esas imputaciones son con un capítulo de conducta sexual con un menor de edad, un delito de la clase 1.
One count of indecent exposure, a Class 6 felony.
Un capítulo de exhibición indecente, un delito de la clase 6.
And one count of molestation of a child, a Class 2 felony.
Y un capítulo de abuso deshonesto de un menor en pubertad, delito de la clase 2.
Before I determine whether I have found probable cause on these allegations or not, I will give each side an opportunity to be heard on probable cause.
Antes de determinar si voy a fallar que existen suficientes indicios, en este caso les doy a los abogados la oportunidad de discutir si hay suficientes indicios o no.
Ms. Hart, I have reviewed the Form 4 in this matter. Is there anything the state wishes me to consider in addition to the information in the Form 4 regarding probable cause?
Señorita Hart, he leído el formulario 4. En este caso, ¿hay algo que el Estado quiere que considere, aparte de lo que está en el formulario 4?
Yes, Judge. There is a significant fact I would like the court to consider, a couple of significant facts, actually.
Sí, su señoría, hay un hecho significativo que me gustaría que considerara. Bueno, algunos hechos significativos en realidad.
One of them being that, as this court is probably aware, Mr. Gonzalez already has an actively prosecuted case in Superior Court.
Uno de esos hechos es, como ya sabrá su señoría, el señor González ya tiene un caso pendiente que se está procesando en el Tribunal Superior.
Which involves allegations, at least to the male victim in that already charged case, that are very similar to this case.
Que tiene que ver con imputaciones, por lo menos en cuanto a la víctima hombre, que son muy parecidos a los cargos en este caso.
And in that charged case, there are at least admissions to some form of sexual misconduct committed by the defendant.
Y en ese otro caso pendiente hay por lo menos unas cosas que el acusado ha admitido, aceptado.
And one other, I think, very significant piece of information is that the victims in the charged case were in the defendant's home as foster children at a separate time from the new victim in this case, which they did not overlap. Sorry.
Otra cosa importante que necesita saber es que las víctimas en el caso pendiente eran niños de acogida que estaban en la casa del acusado en un tiempo diferente que la víctima de este caso, que no coincidieron en el tiempo que estaban ahí.
And I just think that the lack of, I guess, relationship with one another, and so that there's not cross communication, I think is a significant factor that I would like the court to consider in finding PC.
Entonces, el hecho de que no hay ninguna relación entre los dos grupos de víctimas, no hay comunicación entre ellos, es otra circunstancia importante que quisiera que tomara en cuenta.
And then finally, Judge, just as to both the charged case and now this case before you, the victims in these cases were foster children in the defendant's home.
Y la última cosa, señor juez, es que las víctimas del caso que ya tiene pendiente y las de este caso eran niños de acogida en la casa del acusado.
Nothing further. Thank you, Judge.
Eso es todo. Gracias, señora juez.
Thank you very much, Ms. Hart. Mr. Mendoza, anything that you wish the court to consider in regards to probable cause?
Muchas gracias, señorita Hart. Señor Mendoza, ¿algo que usted quisiera que tomara en cuenta en cuanto a los indicios suficientes?
Yes, Your Honor.
Sí, su señoría.
Just as to probable cause, and then I'll talk later as to bond, if any.
Yes.
Solamente en cuanto a los suficientes indicios y luego en cuanto a la fianza, si es que vaya a haber.
Judge, I just asked the court to consider, as I'm reviewing the probable cause statement, there appears to be an accusation by an individual against my client.
Su señoría, al repasar la declaración de los indicios, parece que hay una acusación de un individuo en contra de mi cliente.
It appears that victim references that there may have been other, I'll say, after-the-fact witnesses.
Parece que la víctima menciona otros, voy a llamarlos testigos después del hecho.
But it appears from the probable cause statement, police didn't speak to any of these other potential witnesses at all.
Pero parece en la declaración de los indicios, suficientes indicios, la policía nunca hablaron con nadie de estos individuos.
I don't see anything in the probable cause statement regarding any type of admissions by my client as to this conduct.
No veo nada en la declaración sobre suficientes indicios de que mi cliente haya hecho una declaración sobre esta posible conducta.
And despite the probable cause statement having a lot of detail about things,
a pesar de que la declaración en cuanto a suficientes indicios tiene muchos detalles,
it appears to be an accusation by one individual against my client, and I don't believe that's sufficient for probable cause.
Parece que es una acusación de una persona en contra de mi cliente y no creo que eso sea suficiente.
Thank you, Mr. Mendoza.
Gracias, señor Mendoza.
Okay, I have, like I said, reviewed the Form 4. I have heard argument from both lawyers. I'm considering the arguments made by both lawyers.
Ok, como he dicho, he leído el formulario 4 y he escuchado los argumentos de ambos abogados. Estoy considerando los argumentos de ambos abogados.
Based on the information in the Form 4, for purposes of this stage in the proceeding, I am finding probable cause to support the allegations.
Basándome en la información en el formulario 4, fallo que sí existen suficientes indicios para este paso de los procedimientos.
I hear and understand Mr. Mendoza's arguments regarding lack of admissions and lack of potential interview of referenced other after-the-fact witnesses.
He escuchado y considerado el argumento del señor Mendoza sobre la falta de admisiones y la falta de entrevistas de posibles testigos después del hecho.
Mr. Gonzalez, I want you to understand that my finding of probable cause here this morning
Señor Mendoza, quiero que usted comprenda que el hecho de que estoy fallando que sí existen suficientes indicios aquí esta mañana
is not a determination that you are guilty of these alleged crimes.
no es una determinación de que usted es culpable de estos supuestos delitos.
What my finding of probable cause means is that if law enforcement has the facts and evidence that the Form 4 indicates that they have,
lo que significa mi fallo sobre suficientes indicios es que si los agentes de orden público tienen las pruebas y declaraciones que dicen que tienen,
those facts and evidence would meet the minimum requirements of the alleged crimes.
Esos hechos y pruebas entonces cumplen con los requisitos mínimos para fallar suficientes indicios.
So at this early stage in the proceeding, I am determining probable cause has been found and this case can proceed to further investigation and proceeding.
Entonces, en este paso al principios del caso, he fallado que existen suficientes indicios y se puede seguir adelante con el procesamiento e investigación.
I do note Mr. Mendoza has filed a limited notice of appearance on your behalf for purposes of this hearing.
He visto que el señor Mendoza ha presentado una notificación limitada de comparecencia de su parte, de usted, para propósitos de esta audiencia.
You have the right to make an agreement with Mr. Mendoza or any other private lawyer for representation after this hearing.
Usted tiene derecho de hacer un arreglo con el señor Mendoza o cualquier otro abogado privado para que lo asesore después de esta audiencia.
However, if you do not make any agreement with Mr. Mendoza or another private lawyer,
sin embargo, si no hace un acuerdo con el señor Mendoza o otro abogado privado,
I am determining that you would be entitled to a public defender.
Estoy determinando que usted sí tendría derecho de tener un defensor de oficio.
So I will appoint the public defender's office to represent you for proceedings following this hearing.
Entonces voy a nombrar la defensoría de oficio para asesorarlo después de esta audiencia.
But if you make an arrangement with a private lawyer in lieu of the public defender, that lawyer will know what to do to get the public defender to withdraw.
Pero si usted contrata un abogado privado en vez del defensor de oficio, entonces ese abogado sabrá cómo se tiene que hacer para que se retire el defensor de oficio.
Let me cover next court hearings before we get to release conditions because I don't want to forget to give those hearing dates.
Ahora quiero darle las fechas de sus próximas audiencias antes de las condiciones de libertad para que no se me olviden.
Your first hearing in this matter will be a status conference April 2nd at 8:30 in the Superior Court downtown.
Su primera audiencia, en este caso, es una consulta de actualización el 2 de abril a las 8:30 en el Tribunal Superior aquí en el centro.
Your second hearing will be a preliminary hearing April 4th, also at 8:30 downtown.
Su segunda audiencia será una audiencia preliminar el 4 de abril, también a las 8:30 en el centro.
Okay, now to the matter of release conditions. I would like to please hear recommendation and or argument regarding release conditions from the state first.
Entonces, en cuanto a las condiciones de libertad, primero quisiera escuchar argumentos o recomendación del Estado en cuanto a sus condiciones de libertad.
Thank you, Your Honor. The state is asking for this court to impose a $200,000 cash bond.
Gracias, señoría.
Sorry.
El Estado pide que usted ordene una fianza de $200,000 en efectivo.
And while the state recognizes that the other case is a separate issue, the state would point out that the court can consider that he's already charged with a very similar crime.
Y aunque yo comprendo que el otro caso es un asunto diferente, su señoría puede considerar que ya se ve acusado de ilícitos parecidos.
And Judge, I would submit to you, because of not only the pending case, but also this case, which contains a very weighty sentencing structure. If he loses at trial, the incentive to possibly leave the jurisdiction would be significant.
Y su señoría, aparte de que tiene el otro caso pendiente, en este caso, con la posibilidad de unas penas muy largas si perdiera el juicio, eso le daría motivación para salir de la competencia de este juzgado.
Furthermore, Judge, because yet another child who was entrusted in this man's care in the foster care system has come forward, the state submits that this is an appropriate bond.
Además, señora juez, el hecho de que otro menor de edad que a quien se le había dado con confianza en el sistema de casas de acogida de este estado ha hecho estas acusaciones.
And then, Judge, I guess finally, if the defendant does post whatever bond the court does elect to impose, the state would ask that the statutorily required electronic monitoring be imposed. Obviously, I know he's subjected to that in his underlying case, but also would ask for a curfew to be imposed.
Por eso esta cantidad de fianza sería apropiada. Y también, señor juez, en caso que él pagara cualquier fianza que se fijara y saliera en libertad, el Estado pide que se ordene la vigilancia electrónica, aunque sé que ya tendría esa condición en su otro caso.
That's it. Thank you, Judge.
Eso es todo. Gracias, señor juez.
Thank you very much, Ms. Hart. Okay, Mr. Mendoza, response to the state's request and your own request or recommendation regarding release conditions.
Gracias, señorita Hart. Ahora, señor Mendoza, ¿cómo responde a lo que recomendó la fiscal y qué es lo que pide usted en cuanto a sus condiciones de libertad?
Thank you, Judge. I'd ask the court to consider the purposes of bond in setting this, as I understand them to be protect the community as one.
Su señoría, yo le pediría que tomara en cuenta el propósito de una fianza. Número uno es proteger a la comunidad.
Protect any alleged victims.
Proteger a cualquier supuesta víctima.
To secure the appearance of the defendant at future court hearings.
Para asegurar la comparecencia del acusado en sus futuras audiencias.
And to make sure the community is safe.
Y asegurar la seguridad de la comunidad.
These same conditions were considered previously in his other case.
Se consideraron estas mismas condiciones anteriormente en su otro caso.
The other case the state referenced, he was released after he posted a bond in that case.
Mencionó la fiscal que en el otro caso él fue puesto en libertad después de que pagó una fianza en ese caso.
In that case, my client's family posted $100,000 bond,
En ese caso, la familia de mi cliente pagaron una fianza de $100,000
and he was released to go back to his home with electronic monitor.
y fue puesto en libertad para volver a su casa con el monitor electrónico.
That's where he was yesterday when the police went to his home and arrested him on these new allegations.
Ahí es donde estaba él ayer cuando fue la policía a detenerlo por estas nuevas imputaciones.
And he has been out of custody for several months now.
Y había estado en libertad ya hace varios meses.
And he has come to court each and every time he's had to.
Y siempre se ha presentado en todas sus audiencias.
And in that case, he's also facing a substantial amount of time in the Department of Corrections if he is convicted.
Y en ese caso también se está enfrentando una pena bastante larga en la penitenciaría si es que lo fallaran culpable.
My point is, he's already out on a bond, he's in the community, and he's shown up to court showing he's not a flight risk.
Mi punto es que ya está en libertad él con una fianza que ha pagado y se ha presentado en sus audiencias y demostrado que no es un peligro para la comunidad.
He doesn't have any minor children living in his home.
Él no tiene menores de edad viviendo en su casa.
He has no current contact with any of the former foster kids, alleged victims that have come forward.
No tiene contacto ya actualmente con ninguno de los supuestas víctimas, los niños de acogida que han hecho las acusaciones.
And so there's not a concern about him contacting them now if he hasn't been doing that before since he's been out.
Así que no hay ninguna preocupación de que se contacte con ellos ahora como no lo ha hecho antes cuando estaba afuera.
As I'm sure the court knows, he and his wife can no longer have foster kids or have minor kids in the home in any way, shape, or form.
Como estoy seguro que ya sabe su señoría que él y su esposa ya no pueden tener niños de acogida ni menores de edad en su casa.
I read somewhere, I don't think it was the addendum, maybe the original Form 4, that he and his wife were reapplying to be foster parents.
Leí en alguna parte, no creo que fue en el anexo, a lo mejor el formulario 4 original, que él y su esposa estaban pidiendo ser padres de acogida otra vez.
That's not true.
No es verdad eso.
They can't do that, obviously. He can't be around minors. That's his conditions in his other case.
No pueden hacer eso. Él no puede estar donde hay menores de edad, es una de las condiciones en su otro caso.
And I point all that out, Judge, just to point out there is a record here of him complying and not being a flight risk and not being a danger to the community.
Le señalo todo eso, señoría, para que conste que él ya ha demostrado que no hay peligro de que se huya de competencia ni es peligro en la comunidad.
And if he had a $100,000 bond before, I don't know why the state's asking to double that now. I'd ask the court not to do that and consider his performance on release previously in the other case and imposing a bond here.
Y si él tenía una fianza de $100,000 antes, no sé por qué el Estado ahora está pidiendo el doble y que pido que tome en cuenta su cumplimiento en su otro caso al decidir la fianza en este.
And I'd ask the court to consider all those things in imposing a bond in this new case.
Le pido a su señoría que tome en cuenta todas esas cosas al considerar la nueva fianza en este caso.
And consider releasing him on the same conditions he previously had.
Y que considere ponerlo en libertad bajo las mismas condiciones que ya tenía anteriormente.
This is not a new victim or a new allegation. It's something from the past, so he's not committed a new offense while he's been out.
Esto no es una nueva acusación, nueva víctima que ha sucedido desde que ha estado en libertad, es algo del pasado.
Thank you, Your Honor.
Gracias, señoría.
Okay, thank you both for your arguments and recommendations.
Ahora, gracias a los dos por sus argumentos y recomendación.
As Mr. Mendoza has correctly pointed out, it is the court's responsibility to weigh several factors in determining release conditions.
Como ha señalado correctamente el señor Mendoza, es la responsabilidad de la juez tomar en cuenta estas condiciones y hechos.
The first of those two is to ensure the safety of alleged victims and the safety of the community.
Las primeras dos son de asegurar la seguridad de la supuesta víctima y la seguridad de la comunidad.
In weighing those factors, the court has substantial concern regarding the position of trust over the alleged victims in this case.
Al considerar esas circunstancias, tengo bastante preocupación sobre la posición de confianza que el acusado tenía sobre las víctimas de este caso.
The court also considers that research suggests that individuals subjected to allegations such as these posing or showing an interest, a sexual interest in children, pose a substantial risk to the community.
Las investigaciones han indicado también que para la gente así que demuestra un interés sexual en los menores de edad son un peligro bastante grande para la comunidad.
Those factors, therefore, weigh in favor of a bond in this case.
Por lo tanto, esos factores van a favor de fijar una fianza en este caso.
The court also considers the apparent strength of the state's case at this stage in the proceedings and potential consequences if convicted.
Se ha considerado también la solidez aparente del caso del Estado y las penas posibles en este procedimiento.
In weighing these factors, I do note the pending case with similar allegations, despite my lack of information regarding the substantive facts in that case.
Al juzgar estos factores, he tomado en cuenta que el otro caso pendiente tiene imputaciones parecidas, aunque no conozco los hechos del otro caso.
So in terms of the court's reliance on that other case, it is simply a reliance in terms of review of a criminal history that there is a pending case with similar charges.
Entonces, en cuanto a mi consideración de ese otro caso, es simplemente consideración de que tiene otro caso pendiente con imputaciones parecidas.
I do take into consideration Mr. Mendoza's statement or argument that the strength of the state's case at this stage in the proceedings appears to be testimony or allegations from the alleged victim.
He tomado en cuenta el argumento del señor Mendoza que la solidez del caso del Estado en este momento parece que es la declaración de una persona en contra de él.
I do note that in sex cases, the testimony of the alleged victim is in and of itself sufficient evidence.
Noto que en los casos sexuales el testimonio de la víctima es suficiente prueba.
If believed and found credible by the jury.
Si los jurados lo creen y fallan que es confiable.
But I do also note that there are avenues, according to the Form 4, that appear to be yet unexplored.
Pero también noto que hay otras avenidas posibles, según el formulario, que quedan por explorarse todavía.
Nonetheless, I do hear Ms. Hart's argument that the potential consequences, if convicted of these allegations at trial, are severe.
Sin embargo, escucho el argumento de la señorita Hart que las consecuencias posibles si lo fallaron culpable después del juicio son severas.
The court does not take lightly that this could potentially be the second case in which the defendant faces those severe consequences.
No lo tomo en ligero el hecho de que este es el segundo caso en el cual el acusado se enfrenta a esas consecuencias severas.
that does give the court some concern that the defendant poses a potential flight risk.
Eso sí me da algo de preocupación de que pueda ser riesgo de huirse el acusado.
That factor also weighs in favor of imposing a bond in this case.
Ese factor también va a favor de imponer una fianza en este caso.
Based on all of this information, I am imposing a $150,000 secured appearance bond.
Basándome en toda esta información, voy a ordenar una fianza de $150,000 para asegurar su comparecencia.
If that bond is posted, Arizona law does require electronic monitoring.
Si se pagara esa fianza, la ley de Arizona obliga la vigilancia electrónica.
A curfew will be imposed by pretrial services.
Se impondrá un toque de queda por la Agencia de Control de Procesados.
It is not the court's intent to require Mr. Gonzalez to wear 2 ankle monitors if he's released in this case.
No es mi intención de que el señor González tenga que usar 2 monitores en el pie si fuera puesto en libertad en este caso.
If this bond is posted and he is released, pretrial services should be able to work out monitoring under both cases with 1 monitor.
Si pagara la fianza saliera en libertad, la Agencia de Control de Procesados debe de poder supervisarlo, monitorearlo por los 2 casos con un solo monitor.
If this bond is posted and Mr. Gonzalez is released, I am ordering no contact with alleged victims or any other minors.
Si se paga la fianza, el señor González esté puesto en libertad, ordeno que no tenga contacto con la víctima menor de edad.
Anything else I need to address before I excuse this matter, Ms. Hart?
¿Algo más de que tengo que hablar antes de terminar este caso, señorita Hart? No, gracias, señor juez.
Anything from your perspective, Mr. Mendoza?
¿Algo más de su perspectiva, señor Mendoza?
No, Your Honor, thank you.
No, señor, gracias.
Okay, thank you all very much. This matter will be excused. I think we're printing paperwork now to give you. Mr. Mendoza, I have one more matter on this calendar. If you want a quick minute with him in the room, you can take it.
Okay.
Ya se acaba este caso, se están procesando los documentos.
Thank you, Judge.
Okay, thank you very much, Madam Interpreter. We very much appreciate your translation.
Okay, thank you, Your Honor. Have a good day.
You too, thanks. Okay, can I please have Samuel Lucas Rios into the courtroom, please? Can I have your name and date of birth, please, sir?
Yeah, Samuel Lucas Rios, December 3rd, 1986.
Thank you very much, Mr. Lucas Rios. You are here on allegations of new charges. The allegations against you are 2 counts of sexual conduct with a minor and 2 counts of sexual abuse. All 4 of them are Class 2 felonies. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference April 2nd, and then a preliminary hearing April 4th. Both of them will be at 8:30 in the morning in the Superior Court downtown. And on these allegations, I have imposed a $150,000 secured appearance bond. Arizona law requires that if that bond is posted, you be affixed with an ankle monitor prior to your physical release from custody. If you post that bond and you are released on that ankle monitor, you are ordered not to have contact with any alleged victims or witnesses of the underlying allegations. You are also prohibited from having contact with any minors. Last, you are ordered not to possess any drugs without a valid prescription if you're released from custody. And if any orders of protection have been or are later served upon you, you must strictly comply with the terms of those orders. Do you understand those conditions?
Yes, ma'am.
Okay, thank you very much. You can step back and get.
I have a question.
Sure.
So if this is all happening with all this bond, that means they're putting me as guilty for what happened?
No. At this stage in the proceedings, these are only allegations. So the state has alleged that you've committed these violations or these crimes. I have reviewed the factual information that the state or law enforcement has provided me. What I've determined at this stage in the proceeding is that if the facts alleged in that document are true, and if law enforcement and the state get the evidence that they say that they have, that information does meet the legal elements of the crimes alleged. Whether or not you are guilty of these crimes will be up to a jury down the road. Once you have a lawyer, there will be additional proceedings. You'll go through all the criminal proceedings, and a jury, unless you accept a plea, a jury will determine whether or not you are guilty of these crimes.
Okay.
So the purpose of this bond is not to say that you have committed these crimes. The purpose of this bond is to say that the state's evidence, if they can gather it, is enough to suggest that you being released without a bond pose a substantial risk of harm to specifically minors in the community. So this bond is imposed to protect those minors, to protect the community, and to ensure that you appear at all of your court hearings given the substantial consequences if convicted.
Okay.
Okay, any other questions?
So I'm not getting out until I finish all this process with...
Well, you have a bond. So if you post that bond, you can be released from custody on those conditions. If you do not post that bond, you'll stay in custody at least until April 2nd. On April 2nd, at your first hearing, your assigned lawyer will be present. You and your lawyer can talk about these release conditions, the facts of the case, and your lawyer can then petition the trial court if your lawyer thinks it's appropriate to modify these release conditions.
Okay. I'm just saying because I really don't want to lose my job. I really have a good job, and I don't want to lose opportunity to keep building up money because me and my wife separated like 2 years ago. And I still provide for my daughter every paycheck. I give her, even though she didn't put child support on me or anything, I didn't know she had a restriction order against me. They just told me as soon as I was with a detective, and they told me, you have a restraining order. I'm like, well, you guys never called me. You guys never told me anything about that. So they're like, that's why your daughter blocked you from this, and that. And I'm like, okay, so how do I know that when you guys didn't even come up and tell me or anything?
Here's what I'll tell you. In your release order, you have the phone number to the public defender's office. So you will have a lawyer present at your hearing on April 2nd. It is your lawyer that will be interested in all of this information.
Okay.
Talk to your lawyer at a minimum on April 2nd when you're in court, but you have the phone number to the public defender's office if you want to try to call and talk to a lawyer before that hearing.
All right.
Okay, thank you very much, sir. You can step back and get your paperwork. Okay, that concludes the 8 a.m. initial appearance calendar. This court will stand in recess until 11 a.m.
All right.
Are they ready? I knew how to log in. Thank you. Please be seated. Are we ready? Yes. Oh, okay. I knew I had to log in. Okay, are they in the meeting? Okay, thanks. All right, I just need a minute to get logged in. All right, let's go ahead and get started. And as far as I know, the only interpreter matter we have got moved to the 2, so we don't have an interpreter in the meeting, I hope. I'm still logging into Teams. Okay. All right, this is the 11 a.m. initial appearance calendar for March 27, 2025. The court's orders for the taking of DNA and fingerprints by the Sheriff's Office that were given on the first calendar of the month will also apply to these hearings. And just one more moment, I'm still trying to get this to log in. Okay. Alrighty, we are going to start. Let me see. Let's go ahead and start with number 32, so we can get counsel out of here. Crucita Leon, will you please come all the way to the podium? And I'm going to work to get my camera on here, counsel. Give me a second. Okay, there we go. All right, thank you. Okay, alrighty. This is your initial appearance, ma'am. Can you start with your full name and date of birth?
Lucita Leon, 42690.
Okay, thank you. And then the appearance of counsel, please. You're muted.
I'm sorry, Your Honor. Read with the state.
Okay, thank you. All right, Ms. Leon, I've got a prosecutor appearing in your case. I can hear, you'll be able to hear her. I can see and hear her. All right, Ms. Leon, you have been arrested on the following allegations. Reckless manslaughter, a Class 2 felony. Transportation for sale or sale of narcotic drugs, that's a Class 2 felony. Possession of narcotic drugs for sale, a Class 2 felony. Sale of lethal fentanyl, that's a Class 2 felony. 3 allegations of possessing narcotic drugs as Class 4 felonies. 3 allegations of using an electronic communications device to facilitate a drug transaction, and those are Class 4 felonies. Finally, 3 allegations of possessing drug paraphernalia, which are Class 6 felonies. The alleged offense dates in your case range from November 27th of last year to February 4th of this year. And based on what the police have submitted, the court does find that probable cause has been presented for each of those allegations. So I am appointing a lawyer for you, and I'm going to give you 2 upcoming court dates. Then I'm going to set conditions of bail or release. Your first court hearing will be a status conference on April 2nd at 8:30 in the morning in the downtown Superior Court. Your preliminary hearing will be April 4th at 8:30. The court address will be on your paperwork. Before I set conditions of bail or release, what did the state want to recommend?
Your Honor, we're recommending that the court set a $500,000 parents bond in this case. I see that the defendant appears she's out of custody, and forgive my ignorance on this, but the reason supporting this is I know that the court has reviewed the Form 4, and this is the first time that we have prosecuted this new charge in Maricopa County for the lethal fentanyl statute. But I do want to highlight that the defendant and the victim met, according to the text messages, at 7:12 p.m. The victim texted that he had arrived, and the defendant acknowledged that. At 9:20 p.m., the victim's mother reported that she believed he was home. And at 10:28 p.m. is when the 911 call came in, when the victim's mother found him unresponsive in the driveway. The facts in this case show that the defendant has been dealing drugs and dealing fentanyl specifically repeatedly, and acting almost as a pharmacist in this case. She did instruct the victim in this case as to how to take the fentanyl powder. She suggested that crushed it and put it into a pill capsule in order to take it, as he hadn't done the powder form before. The CI that asked if they had done this before and suggested that Narcan. She was aware of the dangerousness, showing that she's aware of the dangerousness of these drugs and still distributing them. He dealt to the undercover on February 4th, on February 5th, and on February 19th. Those are just 3 transactions in February alone. that to one individual, and over the course of those transactions, that she made over $1,000, which indicates that she has access to large amounts of cash, and that's one of the reasons that we're suggesting the high amount of bond. I believe that those are all the facts that we have supporting our recommendation.
Okay, thank you. And counsel, I also was, this is the first case I've seen of its nature, and so I was looking at the statute, and from my reading of it, I just want to test my understanding with you, that what she faces on that sale of lethal fentanyl charge is a 5-year sentence on top of the normal class 2 ranges. It's not prison mandatory or flat time, meaning it's not, it doesn't become a dangerous offense or anything like that. But please correct me if I've misunderstood the penalty, this penalty enhancement that the legislature has ordered.
That is our understanding as well. We're still researching whether it would be prison mandatory, but we do not believe it certainly it does not state it in the statute.
Okay, understood. All right, thank you. Ms. Leon, I've considered what's been alleged against you, and I believe that ample evidence has been presented from which a jury could find that the fentanyl you allegedly sold this victim was in fact the fentanyl that killed him. And so there is definitely probable cause for these allegations, as well as probable cause for sales to the police on subsequent occasions, which those later sales could indeed become prison mandatory depending on whether you were convicted of earlier dates. We would call that multiple offense sentencing. I haven't been, I've been downtown involved in sentencing in quite a few years, counsel, but there's still some form of multiple offense sentencing, right?
Oh, yes, Your Honor, there certainly is. So that she would be prison mandatory in the second, third, and fourth offenses, and those would count as her second, third, and fourth felonies. Okay.
So ma'am, I've also considered that not necessarily for the sale of the lethal fentanyl, but for the subsequent alleged sales to undercover officers, you could indeed be prison mandatory in this case. I've considered all of those things, your criminal history or relative lack thereof, your apparent ties to the community, all of the things that the court is supposed to contemplate in a case like this. And the court does not believe that a cash bond is appropriate, but I am going to set a $500,000 secured appearance bond in your case. That means you can use a bail bondsman to potentially put up $500,000 in collateral and pay a fee of $50,000 that you don't get back, approximately 50. It's up to the bail bondsman. So you've got your court dates. You also have written conditions. One second. I have to, yeah. So I'm going to note, when I say don't go to the scene of the alleged crimes, that's anywhere you are alleged to have committed these crimes. No contact with the alleged victim's family or next of kin. I've given you some detail in my order about who victim's rights applies to. No weapons, no drugs without a valid prescription. And everything you need to know is going to be on your paperwork. Counsel, anything else before we print that?
No, thank you, Your Honor.
All right, so you've got your court dates, ma'am. They are next week, and we're going to get that paperwork printed up and sent out to you. If you go have a seat, we'll send it out. Thank you. Thank you. All right, thank you, counsel. You're welcome to disconnect.
Yep.
All right, Mr. Nuanez, Reynaldo Nuanez. Where's Reynaldo? Okay, and then Maurice Taylor, will you go to the chair, please? All right. Good morning, sir. May I have your full name and your date of birth, please?
Reynaldo Nuanez, July 3rd, 2006.
Okay, thanks. You're here on a grand jury warrant. You have been indicted on a case from last August. The charges are 2 counts of aggravated assault with a deadly weapon or dangerous instrument, and those are class 2 felonies. I don't know the underlying allegations, but the only way you get to a class 2 is if the alleged victim is either a police officer or a child under the age of 15, but they are alleged as class 2 felonies. 1 allegation of drive-by shooting, a class 2 felony. 1 allegation of discharging a firearm in the city limits, a class 6 felony. And the grand jury met, they heard the evidence, and they found probable cause to formally charge you with all of those crimes. There is, let's see, I'm going to appoint a lawyer to represent you. If you have other open cases, which you may, it looks like you do, you're going to end up with the same lawyer for all of your cases. And, oh, I forgot, is this guy OPDS? No, I forget. No, we don't know, because he's not non-bondable. He's getting a bond, okay. No, he is non-bondable. I forget, he was one of the OPDS ones, right? I think I missed it. You told me and I missed it. So I do need to reprint this one as well. So I need to send it to the right agency so your lawyer gets it quickly, because I do have to hold you without bail in this case, because at the time you allegedly committed all of these crimes, you were out on pretrial release in an open felony case, and that's that's your weapons possessions case. Wait a minute.
No,
Is
that's
that correct?
No.
Just a minute. No, this may be wrong. Just 1 second, okay? IA 831. Actually, I think he wasn't on release. I have a note from pretrial, but I think pretrial is wrong. Is that what you were going to tell me? Is you were not on release?
I wasn't really. I barely got released.
Okay.
Juvenile corrections when I was 18.
Sentenced July of 24. You came back on a weapons charge August of 24. Yeah, I actually think this is wrong. Okay, sorry. All right, I don't see that you're on release, because when I look at, and I did look at the IA, it was 831, the alleged offense dates on the warrant, it is August 19th. So it wasn't until 10 days later that you were seen on the weapons case. All right, so in this case, I do believe you are entitled to bail. Hang on a second. So we're going to kill that evidentiary hearing. And in this case, it's a $250,000 cash bond ordered by the grand jury judge. I'm going to order that. So, hang on a second. Bail, $250,000. Alrighty. No contact with any victims, witnesses, arresting officers, or co-defendants you may have. No weapons, no drugs, no alcohol. I think you are on probation. If you were to post this $250,000 and be out of custody, you have to call your PO within 72 hours of release. Okay. All right, we do need to reprint that. So you do have bail. I'm affirming what the grand jury judge orders, which is the $250,000 cash with release conditions. So give us a minute to reprint that. We're going to send it out to your left. Thank you. All right, Mr. Taylor, Maurice Taylor. Sorry, I got confused by dates and pretrial notes suggesting that it was non-bailable. All right, Mr. Parsons, will you go to the chair? Dale Parsons. Mr. Taylor, all right, Mr. Taylor, I need your full name and your date of birth, please.
Maurice Taylor, March 8th, 1989.
Okay, thanks. Mr. Taylor, you're here on a new case and a warrant in a pending case. In the new case, you were booked in for aggravated assault on a law enforcement officer, which is a Class 5 felony. There is probable cause for that, as well as resisting arrest, a Class 4 felony. Let's see, I'm going to appoint a lawyer for you. You're going to have the same lawyer in this case that you will in your open case, which is number 12 on the calendar. In that case, you have been already charged with possessing narcotic drugs, a Class 4 felony, and drug paraphernalia, a Class 6 felony. You failed to appear at your sentencing on February 28th, and a warrant was issued for your arrest. So you're going to have slightly different court dates right now. No, it looks like I can put the first one together. That's good. So in the brand new case, you'll have a status conference on April 2nd. In the older case, the sentencing case, just a status conference, April 2nd, because you're not going to be sentenced while you have any open case. So April 2nd is your status conference for both cases. Then in the brand new case, you need a preliminary hearing. That'll be April 4th at 8:30.
Okay.
Finally, in the brand new case, you also need a bail hearing because you have an open felony. There's probable cause for a new felony. The law says I cannot give you bail today. I have to set you for a bail hearing. So I have to hold you until the bail hearing. It is 1 week from today, which is April 3rd, 1:30 in the afternoon. Your lawyer will be there on the 2nd to explain to you what's going to happen at your bail hearing on the 3rd. On your paperwork, it's called an evidentiary hearing, but the purpose of the evidentiary hearing is bail. So it is a bail hearing. Okay. Talk to your lawyer about how that works. I just cannot give you bail today in the new case. You may or may not get bail in that case in a week. Now, in the older case, I'm just going to affirm the bond that was set from your sentencing, and that was $500 secured with condition. Don't even try to post that bond, though, if you're still being held without bond in the new case. Okay. You're going to have the same lawyer for everything. You'll be back in court on April 2nd, which is Wednesday. It's 6 days from now.
So I gotta wait for a week to get bail?
Correct. You can't get bail at all until at least the bail hearing on the 3rd. Some people cut a deal at the status conference and they get out that day. Lots of things can happen. So just talk to your lawyer on the 2nd, but I can't give you bail at all today in the new case.
Okay.
All right. So we're going to get that to you if you take that out to your left.
Thank you.
All right, Mr. Parsons? And then Kevin Romero Rodriguez, will you go to the chair? Hello, sir, can I have your full name and your date of birth, please?
Delray Parsons, September 14, 1992.
All right, thanks. You are here on three things. One is a new case. One is a probation hold in a Proposition 200 case. One's a probation hold in a not Proposition 200 case. Is somebody crying in there? What is it that I keep hearing? Is somebody? Oh, so we got somebody making a bunch of noise, officer. If she needs to go to house call because she can't stop that, let's just do it. I don't want to hear that constantly. That makes it hard to hear, and it's very distracting. All right, Mr. Parsons, you're here, as I said, on three things. I'm going to start with your brand new case. You were arrested for armed robbery, a Class 2 felony. There is probable cause for that, and I am appointing a lawyer for you. I'm also appointing a lawyer in both of your probation cases because the probation department will be filing petitions to revoke your probation in both cases based on this new arrest. All right, your next court date is going to be slightly different for these cases, unfortunately. In the brand new case, the armed robbery, you're going to go for a status conference on April 2nd. That's this Wednesday at 8:30 in the morning. The next day, April 3rd, you'll have your probation hearing, which is a revocation arraignment in the downtown probation court. Finally, on the 4th, you'll have a preliminary hearing at 8:30 in the morning in the new armed robbery case only. All right, in the not Proposition 200 probation case, which is number 36 on the calendar, you are held without bond pursuant to law. You do not have bond at all in that case. In the armed robbery case, bond is set at $50,000 secured with release conditions that include no victim contact, no going to that Circle K at all, or contact with any of its employees. Finally, in the Proposition 200 probation case, you are entitled to bail. Bail is set in that case at $2,000 secured with conditions. But you shouldn't try to post bail in two of those cases if you are still being held without bond in that probation case. Everything's on your paperwork. We're going to get you a copy of that. You can start out with that to your left. Thank you.
Yeah. John, I got a question.
What's your question?
How could they charge me with armed robbery when they never found a weapon? Because wouldn't that also...
Talk to your lawyer about that. You don't actually have to brandish the weapon. It is the threat of force. So talk to your lawyer, and they allege this is on video, sir. So you shouldn't talk to anybody but your lawyer about this case, because there is probable cause for the elements of that crime. If you step to your left, you get a copy of that. Thank you. Mr. Romero Rodriguez. And then Chester Stevenson, we go to the chair. Hello, sir. Can I have a full name and date of birth, please?
Kevin Romero Rodriguez, 1994.
December 17?
December 17, 1994.
Okay, thanks. You were here on a failure to appear warrant in one case and an arrest warrant in a newly filed case. I'm going to start with the failure to appear warrant, which is number 10 on the calendar. You've been charged with transportation for sale or sale of narcotic drugs. It is a Class 2 felony. You failed to appear at a trial management conference on January 27th, and a warrant was issued for your arrest. And we're going to give you a status conference in that court April 3rd, which is 1 week from today at 8:30 in the morning. That is in front of the trial judge, and your bond is $7,500 secured. I'm just affirming what the judge ordered. And you have written conditions in that case that you'll get a copy of. Now, you've also been charged with a case from April of last year, and the charges are 1 count of possession of a weapon by a prohibited person, a Class 4 felony, 1 count of narcotic drug possession, and 1 count of dangerous drug possession. Those are both Class 4 felonies. Again, the alleged offense date is April 23rd of 2024. This comes out of the Phoenix Police Department. So I'm appointing a lawyer for you. You'll get a copy of those new charges from your lawyer. Should be the same lawyer that you have for your other case. Your status conference in this newly filed case will be April 2nd at 8:30, and a preliminary hearing will be April 4th at 8:30. So all 3 of your court dates are next week. And in this newly filed case, I'm going to just affirm their bond. It is $1,700 secured. So whatever $7,500 plus $1,700 is, it's close to $10,000. $9,200 maybe, $9,300. So she'll have the paperwork for you. You comply with your conditions if you bond out. Okay, thanks. Mr. Stevenson? And then Jeremiah Grace, we go to the chair, please. I need Mr. Stevenson. There you go. And then Mr. Grace, you can wait in the chair. Thank you so much.
Thank you, sir. Hi.
Hello, sir. May I have your full name and your date of birth, please?
Chester Stevenson.
What's your date of birth, sir?
June 16th, 1967.
All right, thank you. You are here on an arrest warrant and a probation violation hold. In the arrest warrant case, you have now been charged in a new criminal complaint with 1 count of trafficking and stolen property in the 2nd degree. It is a Class 3 felony. The alleged offense date is October 15th of 2024, and this one comes out of the Scottsdale Police Department. You will get the charge, a copy of the charge, and police reports from your lawyer. I'm appointing a lawyer for you in this case and in your probation case. You're on probation for possession of narcotic drugs for sale, and in that case, probation will be filing another petition to revoke your probation based on this newly alleged crime. So you'll go back to probation court, and your court date there is going to be April 3rd at 8:30. So I'm not sure if I gave you your court dates for the new case. In the new case, your court dates are status conference April 2nd at 8:30. That's the stolen property case, with a preliminary hearing April 4th at 8:30. In between those, on April 3rd, you'll go to probation court. So,
But I don't steal anything. What do you mean?
well, that's literally what they have to prove against you.
You have to prove I stole
You have
something,
a
right?
$5,000. No, they have to prove you trafficked it, sir. So, in any event, talk to your lawyer about the elements of that crime. You have a $5,000 secured appearance bond in each case. That is $10,000 total with written conditions. If you bond out, no contact with any alleged victim in the stolen property case, no weapons, no drugs, no alcohol, call your PO within 72 hours of any release.
So if they find me guilty on that, how much time do I do on that?
Trafficking, a Class 3 felony, presumptive, talk to your lawyer, but with more, you have priors, so with 2 priors, I think the presumptive is in the neighborhood of 11.25 years. But
11.25 years?
Yeah.
I didn't steal anything.
Well, Mr. Stevenson, you really need to talk to your lawyer.
Fuck this, I didn't steal shit.
Well, good luck. All right, Mr. Grace, can you come in, please? And then Lana Massey, you can go to the chair. Hello, sir. Can I have your full name and your date of birth, please?
Jeremiah Grace, 8/21/1999.
All right, thanks. You're here on a new case. You were booked in for possession of a weapon by a prohibited person. It's a Class 4 felony. There's probable cause for that, and I am appointing a lawyer for you. Your next court date is a status conference this coming Wednesday, April 2nd at 8:30 in the morning in the downtown Superior Court, with a preliminary hearing April 4th at 8:30 in the same court. Your bond in this case is $5,000. It is secured. If you bond out, comply with all of your written conditions, and call your federal PO within 72 hours of release. It's very, very likely that you're going to end up with a marshal's hold at the jail if you don't have one already. So before you go posting bond, check with the officers and say, do I have a marshal's hold?
Am I formally charged already or no?
This is not the formal charge. It's not.
Okay,
this is a booking charge, so give me a second.
Okay.
The state will now have, they have
The
2
amount of
days
time.
from today
Yeah.
to get the formal charge filed.
Okay.
If they ask for more information, if they just turn it down and say, we never want to file it, whatever it is they decide, if they don't meet that filing deadline, you get released.
Yeah.
And, like I said, though, you may have a marshal's hold, but
Well-
all that means is the marshals will be called and they'll have 24 hours to come and get you from here and put you in front of a federal judge.
I don't mean to interrupt you. Last time I was here, I don't know if you can see that, like in January, I had other charges that they dropped, or it was the same thing they dropped or whatever.
So you've been through this?
She said that they cannot put a hold on me until I'm formally charged.
Oh, okay, okay,
So,
okay. So now, so you know more about how it
yeah.
works than I do. Okay,
so,
okay. No worries.
so
So
I
then
don't
it's up
have
to you.
one
If
right
you-
now though.
What's that?
I don't have one right now.
No, I don't see that note. Every once in a while I do, but I think that's probably because you're in a warrant status, and if you're not in warrant status with them, then I see what you're saying is they will wait to find out if
Yeah,
it's
she
formally
said
charged.
she can't violate me until I actually,
Understood. Okay, so you could bond out, but
So
then
I
you need to call them, and as everybody knows, I mean, anybody who's dealt with the federal system, I used to be in the federal system, you should take their probation really, really seriously, because federal judges, in the word, one would say, they do not play. So,
I just
call your
did
PO
4 years
within
for my, I know, so.
Call your PO within 72 hours if you bond out, or if they don't file and you are released.
Can I
get in
do a
touch-
bail bondsman, or it's
You
5,000?
can. You can do a bail bondsman. Yes, you can. All right, it's up to you left to get that paperwork.
All right,
Okay, thank you. All right, Ms. Massey, Lana Massey, and then Robert Silvius. Will you go to the chair? Hello, ma'am. Can I have your full name and your date of birth, please?
Lana Marie Massey, 9/21/85.
All right, thanks. You're here on 3 things. 1 is a new case, and 2 are probation warrants. In the new case, you were arrested for possessing both narcotic and dangerous drugs. Those are Class 4 felonies. Also, drug paraphernalia, a Class 6 felony. There is probable cause for those, and I am appointing a lawyer for you. You were already in warrant status in both of your felony probation cases. The petition to revoke was filed last December 3rd. The petition alleges that you violated terms 3 and 5 of your probation. You'll get a copy of those petitions from your lawyer. You're going to end up with the same lawyer for everything. Right now, you have slightly different court dates. In the brand new case, your first one is this Wednesday. It's a status conference, April 2nd at 8:30 in the morning in the downtown Superior Court. Your preliminary hearing will be Friday, April 4th at 8:30 in the morning. In between those two, you'll go to probation court, which is April 3rd at 8:30 in the morning for a revocation, arraignment, and possible disposition hearing. In the new case, your bond is $1,000 secured. In each of your probation cases, it is $500 secured for $2,000 total. If you bond out, comply with all of your conditions, call your PO within 72 hours. The main number will be on your paperwork, and the officer is going to hand you that. You can step out to your left.
Thank you.
Thank you. Mr. Silvius? And then Brittany Rodriguez Porter, will you please go to the chair? Hello, sir. May I have your full name and your date of birth, please?
Yes, Robert Silvius, 32189.
All right, thank you. You are here on a probation warrant. You're on probation for a Class 6 felony. There was already a petition to revoke your probation filed back on February 4th, and it alleges, wait a minute, of 2023. It alleges that you violated terms 3 and 5. No, I apologize. It is 2025. It's just very difficult to read. February 4th of 2025. Okay, hang on a second. I need to reprint this one. I had misread that date. I thought it was 2023, and I was holding that against you. So your bond is $250 secured. I just looked at a different spot where I could read it better. It was just this year. All right, your bond is $250 secured. If you post it, comply with all of your written conditions and call your PO within 72 hours. We just need to get it reprinted because I had doubled the bond thinking that you'd been in the wind for 2 years, but this just issued not quite 2 months ago. So, all right, we're going to get that reprinted. We're going to send it out, all right?
So would my bail be lower to what it initially would be, like $50 normally?
Yeah, no, I don't do $50, sir. I believe that is deeply unfair to the people. There's like 2 people that order $50 bonds when they issue the warrant. And this court, I do not affirm $50 bonds in probation cases.
Yeah, that's what I was told initially. My bail
do not.
would be for...
Because I know how much it takes to get violated, and sir, they allege that you got reinstated and went instantly into the wind. I do not hold with that, and if I were the probation judge, I would hold you no bond. Okay. And so there's a couple of people who I deeply disagree with how they handle this. That's them, that's me. Right. My name goes on this order. I will not do it. Right. And it is deeply unfair to all of the other people, none of whom get a 50, that there's a couple people out there that like to do this. And so I disagree. And in fact, I think if you talk to her, she'd say, listen, I order what I order, you will order what you order. It is my decision today, and I will not do that. So please step to your left, take your paperwork. Cool. Ms. Rodriguez Porter. And then Lachelle Peshlikai, will you go to the chair? Hello, ma'am, can I have your full name and date of birth, please? What's your name, ma'am?
Brittany Rodriguez Porter.
What's your date of birth?
6/30/1989.
Thank you. You're here on 3 things. One is a new case, and it looks like 2 are probation holds. In your new case, you got arrested for possessing narcotic drugs. It's a Class 4 felony, and there is probable cause for it. I'm appointing a lawyer for you, giving you court dates next week. The first one is a status conference on Wednesday, April 4th at 8:30 in the morning, with a preliminary hearing April 4th at 8:30. That's in the downtown Superior Court, and the address will be on your paperwork. And probation has notified the court that they will be filing petitions to revoke your probation in both of your cases. So you have to go to probation court on Thursday, April 3rd at 8:30 in the morning. That's a revocation, arraignment, and possible disposition hearing. You will have a lawyer appointed in all 3 cases, and in each of these 3 cases, your bond is $500 secured for $1,500 total. If you bond out, comply with all of your written conditions. Do not miss your court dates. So we're going to get you a copy of those. You can take them and step out to your left. Good luck, ma'am. All right, Ms. Peshlikai, and then Matthew Constantino. Will you go to the chair, please? Hello, ma'am. Can I have your full name and date of birth, please?
My name is Lachelle Peshlikai. My date of birth is 9/29/1988.
Okay, thanks. You are here on 4 probation violation warrants. You are on felony probation in 4 separate cases, and there were petitions to revoke your probation filed in all 4 of those cases. They were issued March 6th of this year. They allege that you violated terms 3 and 5. You're going to have a lawyer appointed, and you will get a copy of the petitions from your lawyer at your next court date. That court date is 1 week from today, which is Thursday, April 3rd, 8:30 in the morning in the downtown probation court. That hearing will be what is called a revocation arraignment and possible disposition hearing. Your bonds are as follows. In number 7 on the calendar, which is the victim case, the first-degree criminal trespass, your bond is $500 secured. In each of the other 3, it is $250 secured. That is $1,250 total with written conditions you're ordered to comply with. That includes calling your PO within 72 hours of any release. She's going to get you a copy of that paperwork. You can take that. It's about your left. Thank you.
All right, thank you.
Mr. Costantino. And then Robert Bellamy, will you please go to the chair? Hello, sir. May I have your full name and your date of birth, please?
Matthew Adam Costantino, 123-1989.
Thank you. You're hearing a warrant from the University Lakes Justice Court, which I believe is in Chandler. You've been charged in that court with theft and drug paraphernalia possession, both as Class 1 misdemeanors. And your arraignment hearing there is going to be April 1st, which is this Tuesday at 8:30 in the morning in the University Lakes Justice Court. I'm affirming their bond, which is $100 secured with written conditions that include: don't go to the scene of the alleged crime, no contact with any alleged victim, witness, or co-defendant. And if you don't make bond, there will be a lawyer there on Tuesday to help you with the bond issue only. You're not otherwise entitled to a lawyer in this kind of case. Everything's on your paperwork. If you take a copy of that, you can step out to your left. Thank you. Mr. Bellamy. And then Eduardo Vasquez, please go to the chair. Good morning, sir. Can I have your full name and your date of birth, please?
Robert Bellamy, 9/30/82.
Okay, thanks. You are here on a child support warrant from the family court. So we're going to give you a court date in the family court, which is April the 4th at 10 in the morning. That is a week from tomorrow, Friday, April 4th at 10 a.m. You have a cash purge. It's not a bond, but you do have to pay it to get out. It's $400. If you pay it, you still have to go on the 4th. I always say that because family court tells me that people claim they thought they didn't have to go if they paid. So we're super clear, even if you pay, you have to go because people always owe more than what the cash purge is. So if you don't pay it, you stay in custody and the sheriffs will take you over there on the 4th. Everything's on your paperwork. Just take that and it's about you. Thanks. And Mr. Vasquez? And then Desiree Barriente, will you please go to the chair? Hello, sir. Can I have your full name and your date of birth?
Eduardo Vasquez, Your Honor.
What's your date of birth?
6/9.
All right, thank you. You are here because you've been charged in a criminal complaint with offenses from back on September 9th of 2024, and they are aggravated driving under or control while under the influence of intoxicating liquor or drugs. They've alleged it 4 different ways, which, based on your criminal history and the arrest that I saw from that date, they've alleged all of the blood alcohol levels against you. It's one date of crime, September 9th, 2024, and this comes out of the Department of Public Safety. So you got a copy of the charges and police reports from your lawyer. I am appointing a lawyer for you. The next court date is a status conference, April 10th, which is 2 weeks from now, 8:30 in the morning in the downtown Superior Court. Preliminary hearing, April 14th at 8:30 in the same court. Now, this is an unserved summons, meaning the state tried to send you a summons to have the court do it, to politely invite you to come to court. It didn't find you. We don't hold that against you as a missed court date. So in this case, I am releasing you to pretrial services, alcohol testing, and an electronic ankle monitor. And here's why. You have 2 priors for this. People who repetitively do this tend to continue to do it until they kill themselves or someone else. And sadly, it's usually someone else with this behavior. People who do this kind of crime repetitively are demonstrably dangerous. If you came in on this offense with 2 priors and 2 prison terms for this, I would hold you on at least $25,000 because people who repetitively commit this crime hurt and maim entire families sometimes. They are dangerous. So, sir, I believe you are dangerous at any moment you are behind the wheel of a car. I do not believe you have a valid license. I prohibit you from driving so that you're not confused. Even if you have a valid license, I do not care. You are prohibited from driving because people who repetitively do this kill other people with their cars. So you will alcohol test. I've ordered pretrial services not to stop doing it because you test negative. If you test negative, that can only help you. That's great. If you're sober right now, your lawyer will want to know that so they can argue for you, so that they can use it. That being said, the court wants to know you're not drinking so that you're less likely to murder someone with your car. If there were victims in this case, I don't know. There might be restitution victims. So no injury crimes are alleged, but if there was a collision or even with somebody's property, they can claim restitution. So when I say no victims, if there was a collision, that's who I'm talking about. If there was no collision, then it doesn't apply to you.
Okay.
No weapons, no drugs, no alcohol. And as I noted previously, you may not drive regardless of the current status of your driver's license. Everything's on your paperwork. I know you know what is at stake. You know better than most what you're facing. It's a ton of time. If you go down with both of these priors, it's a 10-year presumptive in prison for this. So I hope that is enough to get you to comply. As I said, I wouldn't be doing this at all, except it's from last year, and even the state tried to mail you a summons to politely invite you. So they didn't think that you were necessarily a flight risk. I'm worried that you're dangerous. I want to know where you are so you don't flee and ditch court because you're facing a lot of time. I also want to know that you're not drinking. So I'm releasing you, though. So you got to wait to be hooked up. It's going to happen probably later today. And then you get released. They'll give you the information in the envelope about the testing. Just follow that once you get out. Don't miss your court dates, okay? All right. If you step to your left, you get a copy of all that.
Thank you.
All right. Thanks. Ms. Barriente? And then Devon Thomas. We go to the chair. Hello, ma'am. Can I have your full name and your date of birth, please?
Desiree Barriente, 7989.
Okay, thanks. You got picked up in a new case. You're accused of possessing narcotic and dangerous drugs. Those are class 4 felonies, and drug paraphernalia. That's a class 6 felony. There is probable cause for those, and I am appointing a lawyer for you. Your next court date is a status conference, April 10th, which is 2 weeks from now, 8:30 in the morning in the downtown Superior Court. Your preliminary hearing will be April 14th at 8:30, same court, address on your paperwork. You qualify for release to pretrial services. I know you have priors, but you don't have the kind of priors, the kinds of failures to appear that we know about that would cause me to give you a bond. So I'm going to give you a chance to come to court, fair and square. But you do have priors. Your risk assessment score is about 1 FTA away from turning red. Red generally means we just affirm the bond. And so I'm just trying to warn you, don't miss court.
Okay.
And people in your situation often get probation offers. I think you have 1 felony prior and it's drugs. So people in your situation should not fear coming to court. You need to come to court and talk to your lawyer. If you don't, you're going to wind up back here. Everybody's going to affirm the bond for missing court. So you saw what happens. Plan accordingly. All right. If you step to your left, she'll get you that paper. And don't lose the envelope. It tells you what to do when you get out for pretrial. All right, Mr. Thomas. And let's have Mr. Thomas and Miss Gip. No. Actually, Mr. Thomas. And then after that, I'm going to do the last two together. All right. You are Mr. Thomas. Okay, sir. Can I have your full name and date of birth?
Davon Thomas, 10/7/1998.
Okay, thanks. You're here on a new case.
Yes,
You
ma'am.
were arrested for 1 allegation of third-degree burglary. It's a class 4 felony. The alleged offense date is back on January 27th of this year, 2025. There is probable cause for it, and I am appointing a lawyer to represent you.
Yes,
Your
ma'am.
next court date is a status conference in 2 weeks. It's April 10th, 8:30 in the morning, downtown Superior Court. Your preliminary hearing will be Monday, April 14th at 8:30, same court. It's all on your paperwork. Now, in your case, they appear to have a strong weight of evidence against you. They allege this is on video, but you don't have any felony priors, and this is a property crime, and it was 2 months ago. So I'm going to follow the risk assessment score, which suggests that if I release you on your own recognizance, you're reasonably likely to come to court and not commit new crimes or violate these conditions. If you prove us wrong, this is what happens. So
Yes,
I'm
ma'am.
releasing you. It's not because I don't think they have the evidence against you. It's for the reasons I just said. So you are ordered not to go anywhere near the alleged crime scene, don't have any contact with the alleged victims, come to court, comply with your release conditions, talk to your lawyer, defend your case. If you don't show up or you violate these release conditions, that's what's going to land you back here. But this is a probation-eligible offense. I'm not going to hold you on a bond unless you prove that you have to be, that you won't come to court or comply, because you're presumed innocent. But if you don't show up, you're going to end up held, okay?
Yes, ma'am.
Right, so everything's in your paperwork. It still takes hours to be released. Try to be patient, but you'll be out later today.
Yes, ma'am.
Okay? All right, thanks.
Thank you.
All right, then Ms. Gibson, Mr. Goldberg, will you come in at the same time? Is this faster for me?
Most of the podium, please?
Yeah, right here? Okay, ma'am, let's start with you. Will you tell me your name and date of birth, please?
Both of you can.
Yeah, go ahead, Mr. Goldberg. Right, I'm going to do it at the same time because you're both getting released. Spoiler alert.
Janisha
Okay.
Gibson, 3/29/1980.
And what's your name?
Michael Goldberg, 11/3/74.
Okay, thanks. Both of you got booked in on drug allegations, ma'am. For you, it's just possession of narcotic drugs, a class 4 felony. Mr. Goldberg, for you, it's that charge, narcotic drugs, plus drug paraphernalia, a class 6 felony. Now, in both of your cases, I'm going to appoint a lawyer for you, give you a court date, and then order you released. The reason that I'm doing that is because the police in your 2 bookings They didn't provide enough detail for me to find probable cause that what you had was what they said it was. If I was a betting person, I would bet that it was, but there's a legal standard. They did not meet it. The police didn't do a very good job on your booking, so you're entitled to be released while the case is going on. I very likely might have released both of you anyway, but in this situation, you don't have any other release conditions. You're just entitled to get a lawyer, your court date, and then you get put in the pipeline to leave. So your court dates are the same, both of you, and it is, hold on a second, going to be a status conference April 10th at 8:30 in the morning in the downtown Superior Court with a preliminary hearing April 14th at 8:30. I did appoint a lawyer for both of you because the cases are not dismissed. You're just entitled to hit the street. So I'm ordering that, and everything, I also talk about it on the paperwork, so if you're wondering what just happened, it's described on your paperwork too. Just hold on to that paperwork. Don't miss your court dates, okay? But you should be out in a few hours. If you guys either have a seat or she may have it for you right here. She's got. Okay, sit down. She can take out your paperwork to you, and then they'll put you in the pipeline to be released, okay? Okay. All right, thank you. Okay, then I'm going to do my house calls before I wrap up, officer.
Okay.
And that's going to be Yazin Al-Hariri, I heard was being combative and spitting. And Jose Cabrera, I understood was on suicide watch. This is information that I got from the sheriff's office prior to court. I didn't know, did they tell you anything about Ruben Lopez?
We didn't, she just said.
Okay, hey, officer, how come Ruben Lopez is a house call?
Oh, he got combative, he got removed from.
From the gallery? Okay, so apparently Mr. Oh, thanks. Mr. Lopez got combative with officers and was removed and put into isolation from the court waiting area. So I will see each of those defendants in-house in the cell block immediately after this recording to conduct these initial appearances. Yeah, we're good. I will advise Yazin Ibrahim Al-Hariri, born 1/24/2001, is here in a new case. He was booked in for aggravated assault on a first responder, which his court finds probable cause for as a Class 4 felony, 2 allegations threatening and intimidating, Class 1 misdemeanors, 1 allegation of criminal damage, a Class 2 misdemeanor. There is probable cause for all of those, and I am appointing a lawyer for Mr. Al-Hariri. His status conference will be April 2nd at 8:30 with a preliminary hearing April 4th at 8:30. Those will be in the downtown Superior Court. And in this case, let me double check this. All right, I am setting a $25,000 secured appearance bond with written release conditions that do include electronic monitoring. I'll let him know he can go to the scene of the alleged crimes, no contact with those alleged victims or the police victims, no weapons, drugs, or alcohol. And he has to find an alternative residence. That's the purpose of the ankle monitor. All right. Then let's go ahead with Mr. Garcia, if he's out there. Or did she take him out temporarily?
No. Garcia. Come on then. Can you sign 14 for Berger?
Yeah, 14?
He's back for days.
Oh, that's right. I forgot. Because I was excited. All right. And Mr. Garcia, I need your full name and date of birth, please.
Manuel Ramon Garcia. 6/20/64.
Okay, thanks. Mr. Garcia, you're here on 3 things. One is a new arrest, that is allegations from yesterday. Then you have a grand jury warrant because you've been indicted in a case from last year. And then you have a probation warrant. So I'm going to start with your new case. You're accused yesterday of having committed failure to register as a sex offender, Class 4 felony, failure to provide confirming ID as a registered sex offender, that's a Class 6 felony, false reporting to law enforcement, that's a Class 1 misdemeanor, and criminal trespassing as a Class 3 misdemeanor. There is probable cause for all of those things. They also booked you on a dangerous drug allegation, but for purposes of this hearing only, I did not find probable cause on it because they didn't provide enough specifics about what they allege you had. So talk to your lawyer about that. The drug allegation is not dismissed. I'm just not setting release conditions for it. And I am appointing a lawyer for you in all of these cases. It's going to be same, but you should end up with the same lawyer for everything. Now, the grand jury indicted you previously for 1 count of failure to register as a sex offender, Class 4 felony, back on October 27th of 2023, and 1 count of failure to register as, which is the ID confirmation offense, as a Class 6 felony, which is October 17th of 2024. So one of the charges, the Class 4 is from 2023, the Class 6 is from 2024. But you'll get a copy of the charges and police reports from your lawyer. As I said, you'll have the same lawyer for all 3 cases. So that's the grand jury case. And then finally, you were already in warrant status in your probation case. You were on probation for failure to register. And on October 25th, 2023, a petition to revoke was filed, and it alleges that you violated terms 1, 4, 5, and 15. You've got a copy of the petition from your lawyer. All right, you've got a few new next court dates because these cases are all at different stages of the proceedings. So, first, on April 2nd, you're going to go to a status conference in the brand new case from yesterday. That's April 2nd, 8:30 in the morning. It's a status conference. You'll also have a preliminary hearing in that new case only on Friday, April 4th at 8:30 in the morning. That'll all be on your paperwork. Then on April 3rd, which is a week from today, 8:30 in the morning, you're going to go for both the arraignment hearing on the grand jury indictment and the revocation arraignment on your probation case. So all of your court dates are next week, and those are both at 8:30 in the morning in the downtown Superior Court. All right, as far as release goes, in your probation case, you are held without bond in the probation case. You do not have bond. In the grand jury case, I'm going to affirm the bond that was issued when the indictment was handed down. That's $2,000 cash only plus electronic monitoring. Same thing in the new case from yesterday. I'm going to set $2,000 cash only plus electronic monitoring. Both of those have written conditions as well. But you shouldn't even try to post bond in those cases if you're still being held no bond in your probation case. You have the same lawyer for everything, and you should be talking to that person on Wednesday, April 3rd. Everything's on your paperwork. If you'll step to your left, I'll give you a copy of that. All right, thank you. All right, getting back to my house call, I did prior to Mr. Garcia's case make a record about Yazin Al-Hariri, so I'm going to talk about Jose Cabrera, 9/6 of 90. Mr. Cabrera is here on a warrant from the state of Texas, Bexar County, Texas, and this warrant, let me pull it up, was issued on February 16th of 2016. It says it is a post-indictment fugitive warrant on an original charge of endangering a child. And so I'll advise him that's what it's for. As I noted earlier, Mr. Cabrera was isolated on a suicide watch as a potential danger to himself. So he's not going to be able to consider waiving extradition at this hearing, but I will let him know he can consider that at his next hearing, which I'm going to set for April 7th at 1:30 in the afternoon. We will advise him of and give him a copy of his extradition rights. And I'm going to affirm Texas's bail, which is $10,000 secured. I will explain that to Mr. Cabrera. And then finally, we have Mr. Ruben Lopez, 1 and 2. I also made that house call record about him prior to Mr. Garcia's case a few minutes ago. And so Ruben Lopez, born 8/23/83, is here on two things. One's a new case. The booking is for possession of narcotic drugs, a Class 4 felony, and drug paraphernalia, Class 6 felony. I did find probable cause, and I am appointing a lawyer for him. But he'll have a status conference April 2nd at 8:30, a preliminary hearing April 4th at 8:30, and in between those he'll have a bail eligibility hearing on April 3rd at 1:30 in the afternoon, because he is on felony release in number 2. So in number 2 on the calendar, he's been charged with narcotic drug possession, Class 4 felony. This warrant was issued for him on June 27th of 2023 after he failed to appear for a status conference. So his post-warrant status conference in that case is going to be April 2nd at 8:30 in the morning. That's Wednesday the 2nd. And the address will be on his paperwork. And I'm setting $1,000 secured appearance bond in that case based on the age of the warrant. So I'll have written conditions in that case. So we'll go over this with him, and if anything changes after I conduct these initial appearances in-house with any of these defendants, I will come and update my written release order. The court does not intend to supplement this recording. The final written order will reflect the court's ultimate decision in these cases. And with that, we are going to stand in recess until 2 p.m. this afternoon.